I've written it, not by me. 70, that is before any other bench without me.
May I please, Lordship? I beg to mention
Any
item.
more note by me here, you can mention it, I can pass the order.
Yeah, I beg to mention item 51. Yesterday we have circulated one adjournment slip and I taken consent. So in this case, we have.
You have for the petition.
Petition.
You have consented.
But my lord, 2024 matter. And
Why did you consent?
It is because.
You are for the university.
No, so we are for the private respondent 3
Who is for the university? Mr. Goswami.
No, Dixit, D Gugul.
their affidavit and we have filed our.
That Gitasri Bori, my lord. How did you identify the posts? Reservation vacancy. In a department, you said there are that's a community college. So that's a unit. There is a dispute that whether there is 36 posts or 22 posts. And thereafter you advertised saying that this would be the reservation. How did you apply it to a particular post? That's not disclosed anywhere. And secondly, the person who was you are Langtasa.
Yes.
Huh?
Well, I'm not properly.
How did you? Your father is a Kolita, Kakoti. How did you become an ST?
So the certificate is
certificate. We are not doubting,
so
but if status,
if they
we have
have
not
been
brought it on record.
so that's why we file an affidavit. So
Mr.
I'll go through it.
I'm not, a prayer is made on behalf of the by Mr. A. Chetri, Learned Council, appearing for the response number 3 and 4 for an adjournment in the matter on the ground of
yes. We want to file some affidavit for in response.
for facilitating
For
filing of an additional affidavit by the said
Affidavit in
respondents.
opposition.
Affidavit in opposition by the said respondents. So prayer is not objected to by the Learned Council for the petitioner. Mr. P. N. Goswami, Learned Additional Advocate General, appearing for the respondent university is present. So accordingly, the registry to list this matter again.
On second week of Lordship, March.
Third week. On 24/3/2026.
24 is approximately. Can it be 26, Lordship?
26/3/2026. Yes.
Difficulty, my lord, on
Huh?
next March.
Huh?
27.
You have any difficulty? When you want it?
Before that, my lord.
Give me a date.
13th of
13. Well, let it be fixed on 2nd of April.
12th.
April, it will be.
12th of March.
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 Yes, my lord.
12th of-
Yes, my lord.
12th.
of the list.
Yes.
I please, your Lordship. Lordship, I beg to mention item number 58, Lordship. I'm appearing,
58.
yes, Lordship. I'm appearing for respondent number 6, Lordship, private respondent. We want to file an affidavit in opposition.
Oh, we'll see if it is required. We'll hear the petitioner first. We'll hear the petitioner first. If the petitioner succeeds, then only you come in.
Right.
May I please, your Lordship?
When the matter is called, be here.
May I please, your Lordship?
Read the appellate order.
Yes,
The grievance was 2 marks was given to all.
yes.
That was reduced, but still you steal a march. So let him overcome that, then we will see.
Obliged, Lordship.
May I please, your Lordship?
Yes.
With due consent of the other side, Lordship, I beg to mention item number 59, Lordship. Daily list.
59.
I'm for the BTC. Instruction yet to come, Lordship. I will take instruction, Lordship, in this matter. And 2 weeks' time may be granted, Lordship. In the
No,
meantime,
no.
I will file affidavit.
Let the matter, please. Let the matter, please. Yes. Yes, sir.
Yes, please, Lordship. Lordship, beg to mention item number 52 of today list, my lord.
52.
52, my lord.
Okay, you had circulated out.
Yes, we have some.
You are for the petitioner.
Yeah, no, I'm for the respondent 1 and 2, my lord. Yesterday they have filed their affidavit.
Why?
Yesterday they have filed their
No,
affidavit.
why do you want an adjournment?
My lord, we seek, sometime may be granted, my lord, to seek instruction, my lord.
You have not filed an affidavit. You filed
Yesterday
an
they have
affidavit.
filed their affidavit. In
We have
February.
filed an affidavit in.
Yesterday, my
That's a good reason.
Son, my lord, we need
You are Mr.
V Baswar, my lord.
Huh?
V Baswar, Vinod Baswar.
Vinod Baspo. You are not there.
I'm appearing on behalf of my senior NDK, my lord. Sometime.
A prayer is made on behalf of Mr. N. Deka, Learned Council, appearing for the respond number 1 and 2 for an adjournment in the matter on the ground of personal inconvenience. Prayer is not objected to by the Learned Council for the petitioners. Accordingly, registry to list this matter again after
After
2
2
weeks on a date.
Date,
Lordship, the date may be fixed, Lordship.
Today was the date. Why did you consent? Yes.
Chief Registrar is online.
Yes, Mr. Registrar. What is the exact sequence of events?
Honorable Lordship, myself, Registrar Assam University, I beg to mention that on 2020, May 2020, advertisement was made,
Okay.
and there was an OBC PWD for library attendant, along with many other posts.
Hmm.
And on that advertisement, phase-wise, we have made appointments. And at the time of
that's my question to you. There was a selection that was held together for all the posts.
yeah, selection was held.
Why was the appointments made phase-wise? And how did you select the post which will be appointed first, second, third?
Sir, actually, through DPC, we have selected, and then there were some internal issues. There were some complaints regarding selection. So
Where is your disclosure of those details in the writ petition, in the proceeding?
and so, sir, we internally had to recheck, re-examine, and then we placed it in the executive council. So we had to take it phase-wise. And
Okay.
after phase-wise evaluation,
Where are those
sir, we placed,
materials to satisfy, to authenticate what you are saying?
yes, sir. Sir, actually, there were some questions raised by DDEN, our employee association, regarding, so we need, these were internal and we had to check again.
Hmm.
And by that time, some time was taken, and for
Hmm.
which we couldn't put it up together.
2 years.
So,
for the purpose. 2
finally,
years. And when were the appointments made in respect of the other posts?
the other posts were made prior to October 2021.
And why
at
was
that
the
time,
why was the petitioner's case kept pending?
pending, had to satisfy ourselves. We had to recheck the
Where are those
things
materials?
again.
Where are those materials?
Sir, these are just on the basis of some
We will not accept without
internal
there being
verbal.
codes and materials on record. You can't just make a statement.
Okay, sir. Okay, sir. Okay, sir. But actually, when we made appointment of the earlier candidates, on the basis of the DDEN recruitment rule as framed by the university.
Hmm.
By October 2021, a direction from UGC came that
No, there were
no
three posts of
university
library
could make.
attendant. Mr. Registrar, there were
Yes.
3 posts of library attendant.
Yes, sir.
Post of library attendant. Selection
Yes,
was
sir.
one. Selection was one.
Yes.
Recommendation was one.
Yes, sir.
Why the bifurcation then?
Sir, only for
When
library.
did the DPC make its recommendations here?
Sir,
For
for
library attendants,
attendant, the candidates were. Yes, for PWD candidate, it was taken time because the candidate was very less. Only it was hardly 2 or 1 candidate was there. So university took time, whether on the basis of the selection, where
Now,
only
Mr. Registrar, whatever
1
you
or
have
2
said
candidates
today,
applied.
Mr. Registrar, whatever you have said today, kindly put it on
Yes,
an
sir.
affidavit along with the contemporaneous records.
Yes, yes, sir.
messaging this
Yes,
to
sir, sure.
And I
Sure,
want
sir,
the
because
affidavit to be on record by 6th.
on 6th.
Yes.
Okay, sir. Sure, sir. We will put it on record.
Though not statements, I want the corresponding contemporaneous records, which will
Sure.
envisage a decision-making process on your part.
Okay, sure, sir. We'll make it on record, sir.
Okay.
Thank you for giving us an opportunity, sir. We'll put it on record.
What is his name?
Pradosh Kiran Nath, Dr. P. K. Nath.
Pradosh Kiran Nath.
Mr. P.K. Nath, a registrar, Assam
Yes,
University,
sir.
in terms
Yes,
of
sir.
the directions passed by this court, wide the order dated 25/2/2026 has appeared online. Mr. Nath
Yes,
has
sir.
submitted that the selection for the post of three posts of library attendant was held on
It was placed in the 146th EC on 22nd January 2000, on 12th January 2022.
on 20, the library attendant post selection was held on when?
It was placed in the EC on 12th January
I want the
2022.
selection, date of interview, DPC meetings.
Sir, I have to check it
Okay,
again.
Was
Record.
held
As
on
I am
so
out
and
of
so.
session,
23 to 2020.
21,
23. 23 to 2020.
22.
22.
No, that is before the EC. No, I wonder when was the recommendation made?
the recommendation was made in 2021. Exact date I have to
Was
check
made
it,
in
sir,
the year
because I am right
2021.
now out
However,
of session.
on account of certain processing required to be done in the matter by the university authorities, the
Yes,
a
yes,
delay
sir.
occasioned in placing the case of the petitioner who was selected against the post reserved for persons with a disability bracketed PWD before the Executive Council. Mr. Nath undertakes that an affidavit explaining the reasons arising towards the delay occasioning in placing the case of the petitioner before the Executive Council would be brought on record on or before 6/3/2026, along with the
My lordship, may
contemporaneous.
I make a prayer, sir? May I make a prayer, sir, my lordship? Actually, I am out of station. I'll be returning on 4th. So if I can be given
10. We are giving you
little
time
more.
till 10. 10.
Okay, that will be sufficient, sir.
26,
Thank you, sir.
along with the contemporaneous records wherein the said processing is available. Registry to list this matter again on 10/3/2026.
Much of.
Okay, thank you, sir.
Well, he's silent on the UGC part.
We'll come, Mr. Das. We are also aware of that. Let's wait.
Yes, sir. Regarding UGC part,
No,
if
you bring
required,
it
I
on
will
record
answer,
in writing, Mr. Registrar. You bring it on record.
sir.
We'll
Sure,
believe you for the time being. Yes.
Sir, sure, sir. Thank you, my lordship, sir, for giving me an opportunity.
Please connect with it.
Lordship, the date of recommendation was 26 August 2021.
26 August 2020.
That is at page 47. Lordship. Obliged.
Obliged.
Yes, Ms. Kulda. Where is the reasons?
Yes, Lordship, it's here.
I received one communication, my lord.
No, I want the reasons why he had not furnished instructions to you.
But it was sent to the office of the PCCF. In the meantime, my lord, petitioner issued another writ petition for the post of DCF that was granted. Recently, my lord, that promotion has also been given to the petitioner. So now my instruction is that, my lord, we'll take a call on his
You need not take a call.
retrospective.
We are dismissing his, but I want to know that
Now, my lord,
in spite of the advocate approaching the authorities for instruction, the same was not.
my lord, they actually communicated to the secretary, PCCF office. Some, my lord, so we should also have, my lord, insisted for faster instructions, my lord. Now, my lord, since he has.
So you are the advocate, additional advocate general for the state.
Yes.
I find this is the norm now. Why? If the authorities are not interested to give instructions, fine. Whatever is there, we will follow. But I find this to be
True, my lord, true.
in every case.
True, my lord, true. That is true, my lord. We try our best, my lord. Sometimes, my lord.
In this case, I can just dispose it off. There is no problem. Janaki Raman, I'll apply, dispose it off. I
But
want
why the instructions are not forthcoming?
that if there is something more in the pipeline, which is not evident, I'm not saying
Yes,
Mr. Barbuya will suppress, but that's the experience we have seen, that there may be some aspects not brought.
True,
That
my
is why we give you an opportunity.
My lord, our apologies, my lord. But in the meantime, my lord, since he has been granted promotion to DCF, the next post, so we'll be considering his retrospectivity, my lord, for the post of ACF and DCF both.
That is a matter of right for him.
Yes.
Now tell me why it was not done.
My lord, they have given me this, my lord.
ACF, he has been promoted to DCF.
Yes, then my lord will kindly see that instructions, my lord. He instituted a writ petition in the meantime that my lord finds at third page of that once, my lord. Third page, my lord. So writ petition, my lord. The operative part, my lord, finds at page, internal page 3, my lord, paragraph 10. However, since the Learned Standing Council for Journal has submitted that the writ petition can be disposed of with a direction to the respondent authorities to consider as to whether the petitioner is entitled to be considered for promotion or not, the present writ petition is disposed of with a direction to the respondent authorities to consider the case of the petitioner as to whether the petitioner is eligible as per rules for consideration of promotion to the post of Deputy Conservator of Forest. Next page, my lord, will see. He has serial number 1, my lord, Pankaj Koilta. Now he has been promoted from SCF to DCF. Earlier, his claim was, my lord, his SCF should be given retrospectively with pay and allowances benefit. Now, my lord, we'll be taking a call on both, my lord, on SCF and DCF retrospectively, because his my lord, ground before the Honorable Court while seeking promotion to the post of DCF was exactly identical, that the persons junior to him were already promoted. So definitely, my lord, he'll have a claim for retrospectivity. Both the claims of the petitioner in the post of SCF and DCF, giving retrospectivity, my lord, we will consider. Since because of these, my lord, developments, my lord, perhaps they have waited for some time, my lord.
In pursuance to the order dated 25/2/2026, requiring the Secretary to the Government of Assam Forest Department to explain before this court the reasons for the delay occasioning in issuance of instructions to the Departmental Council, the Commissioner and Secretary to the Government of Assam, Department of Environment, Forest and Climate Change has laid out the said reasons in a communication dated 25/2/2026 issued to Mr. P.N. Goswami, Additional Advocate General, Assam. Mr. Goswami has placed the said communication on record. This court has perused the said communication and finds that the reasons stated therein, although not germane to the issue involved, as the same is the first time. However, considering the unconditional apology tendered by the authority, this court would not proceed further in the matter. Also, it is brought to the notice of this court that the petitioner herein was subsequently also promoted to the post of Deputy Conservator of Forest, while order dated 24/2/2026. Post of. The said aspect of the matter would also now be required to be reckoned by this court while passing final orders in the said aspect of the matter would be reckoned by this court while passing final orders in the present writ petition. Also, in view of the above, raised to list this matter again on 17/2/2026 for further hearing.
My lord, pendency may not be a bar for the authorities to.
That is for you to do.
Okay.
That we will do it for you others.
Leave level.
May I have pleasure?
What is your grievance here?
My grievance is that, Lordship, the final graduation list, Lordship, what I have found, Lordship, the person who is junior, his name is recommended for promotion, Lordship.
Have you made him a party?
Yes, yes. Then immediately I file an appeal. The rules say the 25, if somebody is aggrieved by the graduation list or recommended list, then
You come to the appeal at page 32 and tell me what is the reason ground taken there.
Reason because
No, what is the ground taken? You
Ground
have taken everything in a vague manner that everything is there. But where is the ground?
No, the person who is junior, that is written also.
Where is the ground? Nothing. I came to know that some discrepancy in the gradation.
Lordship,
And
kindly
recommended
see,
list for so and so.
no, Lordship, kindly see
Among
the,
so and so.
teacher and the
Doubtful date of joining.
name
BA
of
degree.
junior teachers.
Further, some teachers whose name has not been reflected are also participating.
Yes, yes. The second case, that is where the name.
Fine, we are in the first case now.
No, in the
What-
first case,
what-
Lordship,
What order what would the appellate authority understood? This court has not understood.
Lordship, the petitioner submitted, Lordship.
We are not
If-
entertaining such petition.
if-
Give me the concrete thing.
Yes, then Lordship kindly come to the recommended list.
Huh.
Recommended list, Lordship, my name, Lordship will find at page, serial number 56, page 35.
Hmm.
Sorry, 25.
Hmm.
Page
Yes.
56, sorry, serial number 56.
Huh.
This is the name of the petitioner.
Hmm.
Now, Lordship, kindly see the date of joining, 28/8/2007.
Hmm.
Now, the person whose name is recommended, his name is at serial number 59.
Hmm.
Now, Lordship, kindly see the date of joining, 29/8 of 2007. So, apparently, Lordship, the petitioner.
What is the criteria?
Criteria, Lordship, the seniority.
Only.
Date of receiving the seniority and 10 years. And
No,
having the-
no screening on merits.
No, Lordship, the eligibility criteria, it says 10 years as graduate teacher, having graduation and BEd degree, and Lordship
This is
receiving.
promotional post, district wise.
Yes, yes, district was nowadays. Now, district selection.
2018 rules.
18 rule, Lordship. Lordship, we're going to rule for 14. Rule 14. Rule 14, 1 and 2, this is the criteria. Then 3. 3 is the procedure, how it is made. Then 3, 2 and 3. Roman 2 and 3. After graduation list,
The district selection committee shall hold interview category wise and prepare
yes,
a panel list of double number of vacancies. So
yes,
there is a merit here,
yes, they prepared, Lordship.
the merit. So you may not have come in.
No, Lordship, that I don't know, Lordship.
You
Lordship,
don't know, but
but
you
apparently
say
it's a-
everything in an appeal. For the namesake, you have made an appeal. This appeal, we are not. We are remanding back, giving you liberty to prepare a detailed appeal before the authorities.
That's true, Lordship, but by this month, Lordship, they are going to fill up the post.
Let them.
No, Lordship.
The end. The world will not end. We can always
Lordship,
bring you
kindly
back.
see the recommended list. Apparently, he is junior, Lordship. That is my
This
case.
appeal, because the
So,
provision is,
appeal, Lordship, there may be
Huh?
some defect, Lordship.
nothing is here. What is the need? It's not only for a namesake that you will make an appeal. It has some meaning.
They are understanding, Lordship.
No.
Yeah.
Headmaster,
No,
you
Lordship.
mean to say that the headmaster has understood only this much? Okay.
Lordship, kindly see the.
Mr.
apparent-
Hurt, Mr. A. Deca,
Lordship,
learned
Lordship,
counsel for the petitioner.
Lordship, kindly see, consider one thing, Lordship.
If the understanding of the headmaster is this,
Lordship, the honor.
then let him be
No, no,
assistant teacher.
Lordship, Lordship, the Honorable Education Minister day before yesterday announced, Lordship, by this month, Lordship, they are going to promote issue.
We are
order.
providing for that.
No, Lordship, some protection, Lordship. At
We are
least, Lordship,
providing full protection.
the-
Don't
the-
worry. We are providing full protection. Lika. Heard Mr. N. Deca, learned
the-
A. Deca, learned counsel for the petitioner. Also heard Ms. D. Mushahari, learned standing counsel, Department of School Education. Also, the petitioner in the present proceeding has said the recommendation, the recommendation of the district selection committee so made for the recruitment against the post of headmaster in the district of Morigaon.
Morning, Lordship.
In the headmaster against vacant posts has assailed the recommendation of the district selection committee, Morigaon, for recruitment against the vacant posts of headmasters in provincialized high school in the district of Morigaon. Mr. Deca has submitted that the private respondent number
5.
5 in the gradation list as published was placed below him, and accordingly, without recommendation being made in favor of the petitioner, it was not open to the respondent authorities it was not open to the district selection committee to recommend the name of the petition of the respondent number 5 for promotion against the post of headmaster by reckoning his scheduled caste status. It is to be noted that the petitioner also belongs to the scheduled caste community. Also, the petitioner submits that being aggrieved, the petitioner has preferred an appeal on 18 to 2026. However, the same remains. However, the same has not been disposed of. Also, Ms. D. Mushahari, Learned Counsel for the Learned Standing Council, Secondary Education Department, submits that there is an element of selection involved in the matter of promotion to the post of headmaster, and accordingly, she would be required to receive instructions as to why the district selection committee had recommended the name of the respondent number 5 ahead of the petitioner hearing. Also, issue notice returnable 4 weeks. Ms. Musahari, D. Musahari, accepts notice on behalf of respondent number 1, 2, 3, 4,
6
5, 6, sorry, 6 and 6, 5 to no. As no formal notice is to be required to be issued, petitioner to take steps for service of notice upon the respondent number 5 by way of speed posting. Also, steps within 2 working days from today. Also, considering the submissions made by the Learned Counsel for the parties, the promotions affected in pursuance of promotion, the selection of the respondent number 5, as well as any order of promotion that may be so issued in his favor, promoting him to the post of headmaster of a provincialized school in the district of Morigaon, shall be subject to further orders that would be passed in the present proceedings.
Lordship, it differs of the appeal, Lordship. If I record,
Appeal is nothing. It will be.
no, I will file a phrase appeal, Lordship. And otherwise, Lordship,
We are considering.
the moment the kindly consider what the moment the promotion order issued, it become
It will not become infructuous. I said it is subject to the outcome.
Lordship, but
Tell me how it is becoming infructuous. You have made a challenge. We will consider that. She will get the instructions.
because since there is a statutory remedy, Lordship, I preferred an appeal.
You withdraw, go. We will not permit. But once you have come here and we find that the appeal is without any ground, we are considering it.
Wait, if just record the petition, you file a phrase appeal, Lordship. I understand what the fake of Lordship.
Next two. Okay.
Till then, the status quo.
This is my order. You can test it. No problem.
So at least status quo we maintain, Lordship.
I'm sorry. This is not a fit case. Second one, no? The second case, respondent number, private respondent is?
Private respondent, Lordship.
5 and 6.
Even Lordship, here, Lordship, his name is not indicated, Lordship. So kindly see the name of the Lordship for a moment. The respondent number 5. His name is not in the recommended list, Lordship.
It would
So
be
what to
clearly.
do, Lordship, here?
Where is that recommended list? Page.
Recommendation form starts from page 22, Lordship. His name is not there,
Respondent
Lordship.
number?
Respondent 5. 6 is junior, but so far the 5 is concerned. His name is not even
Respondent
reflected.
number junior, respondent number 6. Aru, Mr. Deka further submits that the name of the respondent number 5 does not find mention in does not find place in the revision list as published in the matter. Also by the Inspector of Schools, Morigaon. Also. Baki is track over inspection logo. On the said aspect of 5, the respondent number 5 was 6 was promoted, was recommended ahead of the petitioner, and as to why, and also with regard to the contention of the petitioner that the name of the respondent number 5 was not included in the gradation list so prepared for the purpose of promotion to the post of headmaster in the provincialized schools in the district of Pakiaki. We'll see, we'll see, we'll see. They have done something, let them do it, we'll see.
Lordship, the petitioner, that is the moment the appointment order, promotion order issued, there's nothing survived, Lordship.
We have provided that it
So
is
see,
subject
subject
to
to-
appoint, subject
But,
to orders.
but the apparently are making a prima facie case.
Yeah, we are not satisfied. Because there is a selection element.
It's true, Lordship. He also participated. There is no doubt
If you
that-
want to try somewhere else, I can delete this order, give you an adjournment. There is no problem.
No, Lord.
Cut it here. So cut it here. Mr. Deka, Mr. A. Deka prays that he be granted 2 weeks time to place.
Lordship, not 2 weeks, Lordship.
2 weeks time because I may be here next week
So
also.
by this month, Lordship, they going to issue the promotion order.
This month is over
Wait till
tomorrow.
then, Lordship.
This month is over tomorrow.
I will not insist you because apparently this list shows there is Lordship, serious doubt, Lordship. Because the person who is junior, his name is recommended. Person whose name is not reflecting the this list, his
Mr.
name is
Deka.
recommended.
We keep this order, it was my idea. You appeal. A good ground for appeal.
Also, there will be observation that interim order is declined, Lordship. That may be observed.
That is my wish, my order. I'll pass it according to me only. We have said this is the thing. We are refused. Sorry. You can take your recourse. What do you want? Yes, madam.
Blind, Lordship.
हमारे कहीं डीडी बना दीजिए नहीं तीनटा আছে तीनटा repetition আছে I agree तीनटा repetition That's Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. I. Hassan, Learned Counsel for the petitioner in the above noted writ petitions. Also heard Mr. who was appearing for the state, Mr. S. Das.
S. Das.
S. Das, Learned Standing Counsel, Senior Learned Standing Counsel, Higher Education Department, appearing for the authorities in the Higher Education Department. Also heard Mr. K. N. Chaudhary. Also heard Mr. K. Barpujari, Mr. A. Dr. A. Chomuha, Learned Standing Counsel, University Grants Commission. Also heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by
M. Ahmed.
M. Ahmed, Learned Counsel, appearing for the
Respondent.
governing body, Mankachar College, and as well as the selection committee. Selection committee?
No, no.
Only governing body.
Only government.
For respondent number 4. Governing body, Mankachar College in the above noted petitions. Also heard Mr. P.J. Ukan, Learned Standing Counsel, Gauhati University, appearing for the scrutiny committee of the scrutiny committee, Gauhati University, as constituted for selection to the post of principal, Mankachar College. Also heard Mr. P.K. Deka, Learned Counsel, appearing for the respondent number 7 in WPC number 6681/2020.
Yes.
Right?
Yes.
Now you can take your seat. Yes, Mr. Anything you want to? The petition, by way of instituting the above noted writ petitions, have presented a challenge to the recruitment process initiated by the governing body of Mankachar College for against the post of principal of the college. Also, by way of instituting WPC number 5045/2024, the petitioner had essayed the selection of one Dr. Ajibur Rahman as the principal of the said college in pursuance to an advertisement dated 21/2/2022. Also, the same petitioner, by way of instituting WPC number 3018/2025, has presented a challenge to an advertisement dated 29/5/2025 issued by the governing body of Mankachar College for recruitment against the post of principal, which had fallen vacant on the death of said Dr. Ajibur Rahman. In WPC number 6681 2025, the petitioner has presented a challenge to the selection of the respondent number 7 therein as against the post of principal, Mankacha College. The petitioner has also presented a challenge to the recommendation made by the scrutiny committee, Gauhati University, wherein the scrutiny committee had found the petitioner to be not eligible to appear in the interview for the post of principal in pursuance to the advertisement dated 29/5/2025. Right? This is the thing. So, the petitioner in the present proceeding has projected that he was initially appointed as a lecturer in the Department of Chemistry, Mankachar College, and had worked therein with effect from 1/8/2005 till 31/7/2006. Also, it is further projected that thereafter the petitioner, with effect from 1/8/2006, had joined as a lecturer in chemistry at Shillong Engineering and Management College, Jorabad, wherein he projects to have worked till 31/7/2010. The petitioner's further contention is that he came to be appointed as an assistant professor in the Department of Chemistry, Assam Downtown University on 1/7/2010. The petitioner joined the said post and continued against this same. Also, it is further projected in the writ petition that the petitioner, on completion of around 8 years of service as an assistant professor with Downtown University, he was promoted to the post of associate professor with effect from 1/4/2018. The petitioner is found to the materials brought on record. Now, the petitioner further projects that he continued in this said university till 2011/2020 and thereafter, with effect from 21/11/2020, the petitioner is serving as the principal, Crescent College, Gauhati. The petitioner in the writ petition, has further projected that he was granted his PhD degree where is it? 2014.
2014, my lord.
In the year 2014 from the Gauhati University. Also, the petitioner has contended that he was eligible for being considered for a recruitment against the post of principal in provincialized colleges of the state, and accordingly, on such advertisements being issued, he had submitted his candidature against such post. So accordingly, on the governing body of Mankachar College issuing an advertisement on 21/2/2021, inviting application from eligible candidates for recruitment against the vacant post of principal in this college, comma, the petitioner who contends to have fulfilled all the mandated UGC norms, comma, submitted his candidature for recruitment against the said post. Also, the petitioner thereafter projects to have appeared before the selection committee along with one Dr. Ajibur Rahman. Also, on 27/6/2022. It is also contended by the petitioner in the writ petition that Dr. Ajibur Rahman did not fulfill the requisite eligibility criteria as set out in the advertisement dated 21/2/2021. However, he was also called for the interview by the respondent authorities. The recommendation being made in favor of said Dr. Azibur Rahman for appointment as against the post of principal of the said college, and such a recommendation being forwarded to the Director Higher Education Assam for approval, comma, the petitioner initially approached this court by way of instituting a writ petition being WPC number 4683/2022. The said writ petition, however, was dismissed by this court by order dated 27/7/2022 by holding the same to be prematured. This court, however, passed directions to the Director Higher Education Assam to pass final orders in the matter after taking into consideration all relevant particulars. Also, thereafter, the petitioner projects that the director had required the college governing body of Mankachar College to re-verify the selection particulars and thereafter to submit a fresh proposal in the matter. The said exercise was carried out, and the proposal in this, a fresh proposal in this connection being placed before the Director Higher Education Assam, comma, the Director Higher Education Assam proceeded to issue an order dated 28/2024 appointing said Dr. Ajibur Rahman as the principal of Mankachar College. Mankachar. Now the question whether he joined. He did not join.
No, he did not.
Also, it is seen the petitioner projects that although said Dr. Azibur Rahman was appointed as the principal of Mankachar College, comma, he did not join against the said post and unfortunately passed away on 13/2/2025. The above position emanating in the matter required the governing body to seek fresh permission from the Director of Higher Education Assam to issue advertisements for recruitment against the post of, to initiate fresh recruitment process or against the post of headmaster principal of the college. The said permission being granted, comma, the governing body of the college issued an advertisement on 29/5/2025 inviting applications from eligible incumbents for a recruitment against the post of principal of the college. Full stop. The subpara. The petitioner being aggrieved by the issuance of the fresh advertisement dated 29/5/2025, assailed the same by way of instituting WPC number 3018/2025. A coordinate bench of this court wide order dated 2/6/2025, noticing the issues arising therein, while refraining from issuing any blanket interim directions in the matter, granted liberty to the petitioner to submit his candidature against the said advertisement dated 29/5/2025 with the further stipulation that such submission of candidature by the petitioner would be without prejudice to his rights espoused in WPC number 5045/2024, which was pending disposal at the relevant point of time. This court also directed that the respondent authorities shall not take any final decision for appointment in pursuance to the fresh recruitment process, without taking prior leave of this court. Full stop, substop. After the said, no, full stop. In terms of the said liberty granted to the petitioner herein, he submitted his representation. It is found, he submitted his representation against the advertisement dated 29 dated so and so. Also, the petitioner contends that after submission of his candidature, he not being issued with any call letter for appearing before the selection committee, he made inquiries and came to learn that the respondent authorities had, on a scrutiny of his eligibility, found, however, had declared that had held him to be not eligible, and only one Dr. Ibrahim Mondal was found to be the candidate in the fray who had satisfied the requisite eligibility criteria as laid down in the matter by the UGC as well as by the government in the Government of Assam in the Department of Higher Education. Also, accordingly, being aggrieved by his exclusion from the selection process, the petitioner has again approached this court by way of instituting a writ petition being WPC number 6681/2025, assailing the decision of the scrutiny committee wherein he was held to be ineligible for appearing in the interview for the post of headmaster principal in a provincialized college. The petitioner had also presented a challenge to the So the petitioner had also prayed for a direction upon the respondents to allow the petitioner to appear in the interview for the post of principal in pursuance to the advertisement dated 29/5/2025. Also, this court, while issuing notice in WPC number 6681/2025, wide order dated 25/11/2025, had again reiterated the directions passed by this court in the proceedings of WPC number 3018/2025, requiring the respondent authorities not to finalize the selection to the post of principal without a leave of this court. Full stop. Having noticed full stop, this court, having noticed the background leading to the institution of the three writ petitions noticed herein above, would now proceed to consider the submissions made by the learned counsels for the parties. For the purpose of, for convenience, the parties are being now described as they are placed in the proceedings of as placed in writ petition being WPC number 6681/2025, right? Yes, Mr. Fukon, you are the main man. You are sitting backside, huh? No, no, just. If I miss out something, just point it out. Mr. Ahmed, if I miss out something, point it out. Mr. R.P. Sharma, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that the scrutiny committee so constituted in the matter had rejected the candidature of the petitioner solely with the purpose to ensure that the selection of the respondent number 7, Dr. Ibrahim Mondal, is so carried through without any hindrance. Mr. Sharma submits that the petitioner satisfies all requisite eligibility criteria as set out by the UGC for being recruited against the post of principal of a provincialized college in the state of Assam. Mr. Sharma submits that the grievance of the petitioner in the present proceeding is that the petitioner's case has been prevented by the respondent on account of the high-handed action on the part of the respondent authorities from being considered on merits for a recruitment against the post of principal lying vacant in Mankachar College. Mr. Sharma, by referring to the UGC regulations of 2018, more particularly regulation Clause 4, Regulation 4, bracket, Roman dot. Huh? It is Regulation 18.
Clause 4.
Regulation of 2018. Regulation 4 of Regulation 4, more particularly Regulation 4.
No,
bracket.
regulation.
Mr. Counsel, the regulations are numbered as Regulation 1, 2, 3, 4, 5.
Regulation is of 2000.
I know. How are the sub-regulations?
Clause 1.
You describe it as clause 1, 2, 3, 4, 5. Where do I get it?
Regulation.
They are not called as regulations.
The clause in our affidavit.
Okay, your affidavit, we are mentioning it. You go upon appeal and get it set aside. Lekha 4, 5, 4, Roman 5, Dangor, dot, Dangor A. Pertaining to the eligibility for recruitment against the post of principal of a college, submits that the petitioner possesses a PhD degree and being an associate professor, he has a service experience of at least a service experience of more than 15 years he has a teaching experience of more than 15 years in recognized university, colleges and or colleges. Mr. Sharma submits that the petitioner has more than 10 research publications in peer-reviewed or UGC listed journals and has a API score of more than 291. I think it's 291, Mr. Hassan, 242.1. Accordingly, he submits that the petition, having satisfied the requisite eligibility criteria set out by the UGC in its regulation of 2018, there was no occasion for the scrutiny committee to reject the candidature of the petitioner by projecting that he had not fulfilled the requisite eligibility criteria as set out by UGC in its said regulations of 2018. Mr. Sharma has submitted that the petitioner had also submitted his application in pursuance to the earlier advertisement issued for the same very post by the governing body of Mankachar College. That is the advertisement dated 21/2/2021 and pleas similar to the one now raised with regard to the candidature of the petitioner was not so raised in the earlier round, in the earlier recruitment process for the same very post. Mr. Sharma has also submitted that the petitioner had applied for recruitment against the post of principal of various other provincialized colleges, and therein also his eligibility was never questioned. Rather, the petitioner was permitted to appear in the recruitment processes so held in the said colleges. Also, Mr. Sharma, by referring to the service rendered by the petitioner in downtown university, has submitted that he had joined the said university as an assistant professor in the Department of Chemistry with effect from 15/7/2010. Just check the dates, I'm telling you. Sasan, if the dates are wrong, just let me know. 15/7/2010. Thereafter, it is submitted by Mr. Sharma that he was promoted as associate professor in the same very university with effect from 1/4/2018. Mr. Sharma submits that the certificates issued in favor of the petitioner by the said university would establish the veracity of the statement made by the petitioner in this connection. He submits that the order promoting him as associate professor had inadvertently recorded that his such promotion was a redesignation of the post, which Mr. Sharma submits to be an inadvertent error. And actually, he was promoted as an associate professor. Accordingly, Mr. Sharma submits that the petitioner being an associate professor with effect from 1/4/2018 and he having rendered services as an assistant professor in various institutions without break with effect from 1/8/2005, the petitioner must be held to have acquired the requisite eligibility criteria for being considered for appointment against the post of principal in a provincialized college in the state of Assam in terms of the UGC guidelines, in terms of the eligibility criteria spelled out in the UGC regulations of 2018. UGC regulation also, in the above premises, Mr. Sharma submits that the recruitment as held in pursuance to the interview process of interview. In the above premises, Mr. Sharma submits that the recommendation of the scrutiny committee as constituted in the matter, which has the effect of excluding the petitioner from the purview of the selection process, would call for an interference by this court. Mr. Sharma further submits that the interview held in the matter by the selection committee constituted in pursuance to the advertisement dated 29/5/2025 and the recommendation so made by it in favor of the respondent number 7, as well as the resolution adopted by the governing body of Mankachar College recommending the name of the respondent number 7 for appointment against. There is a recommendation. Only, okay, Malay, a selection. Then what is that recommendation? There I found something somewhere. There is a resolution. The governing body, no?
Yes.
That is in the earlier one.
504 points.
That resolution was.
Per contra, Mr. K.N. Chaudhary, learned senior counsel, appearing for the governing body of the college, more particularly respondent, so appearing for the respondent number 4, that is the governing body, Mankachar College, has by referring to the UGC regulations of 2008, more particularly clause 4.5.a, what clause to it? Dr. Chomuha, when Dongwa Chomuha says it's a clause, how can this court say it's not? So we'll follow what Dr. Chomuha has said. Clause submits that one of the eligibility criteria mandated for a recruitment to the post of principal of a college is that the intending candidate must be either an associate professor or a professor with 15 years of experience. Mr. Chaudhary submits that the manner in which an assistant professor is to be promoted to the post of associate professor and or professor is also set out in the provisions of the regulations of 2018, as well as the regulations that had come in, that was in force prior to thereof. He submits that the petitioner in the writ petition in support of his claim of having been promoted to the post of in support of his claim that he was working as an associate professor in downtown university has relied upon a communication dated 1/3/2018 issued by the chancellor of the said university. He submits that a perusal of the said communication dated 1/3/2018 would reveal that the petitioner who was working as an assistant professor in the said university was actually redesignated as associate professor with effect from 1/4/2018. Mr. Chaudhary has further submitted that while the petitioner has projected that he was working as an associate professor in downtown university, the petitioner has not brought on record any materials to demonstrate the manner in which he was so appointed and or promoted to the post of associate professor in downtown university. Mr. Chaudhary submits that the promotion of the working of the petitioner as associate professor in downtown university is clearly in violation of the provisions of the regulations of 2018 and or the regulation in force prior thereto of the University Grants Commission. Mr. Chaudhary submits that the petitioner, having assailed the selection and appointment of Dr. Azibur Rahman in pursuance to the first advertisement dated 21/2/2021, he submits that the plea taken by the petitioner that Dr. Azibur Rahman did not fulfill the requisite eligibility criteria as set out by the UGC is clearly perverse. Mr. Chaudhary submits that Mr. Azibur Rahman submits that the eligibility criteria submits that the selection committee had duly considered the documents relied upon by Dr. Azibur Rahman to satisfy itself that he fulfilled the eligibility criteria so spelled out. He submits that it is only after the selection committee was satisfied that Dr. Azibur Rahman had submitted and had fulfilled the requisite eligibility criteria that he came to be recommended for appointment against the post of principal of the college. Mr. Chaudhary submits that the said proposal being placed before the Director of Higher Education, Assam, the director, while further processing the same, having found certain inconsistencies, the matter was remanded back to the college of the governing body of the college for a re-verification of the selection particulars. He submits that on a due re-verification of the said selection particulars, the governing body of the college had resubmitted the proposal with a recommendation to appoint Dr. Azibur Rahman. He submits that due justifications were also forwarded by the college authorities for the purpose. Also, the Director of Higher Education Assam, thereafter, on perusal of the recommendations made in favor of Dr. Azibur Rahman, as well as the selection records and the subsequent along with the justifications submitted by the governing body, proceeded while order dated 28/20/24 to appoint Dr. Ajibur Rahman as the principal of the college. However, the said appointment, he submits that the said appointment could not fructify inasmuch as Dr. Hajibur Rahman passed away on 13/2/2025. Mr. Chaudhary has submitted that the vacancy in the said post having again arise. Mr. Chaudhary submits that the governing body of the college thereafter sought fresh permissions from sought permission from the director, Higher Education Assam, to issue fresh advertisement for recruitment against the post of head principal of the college. Also, he submits that the said permission being granted, the advertisement dated 29/5/2025 came to be issued by the governing body of the college. Mr. Chaudhary submits that the in pursuance to the said advertisement dated 29/5/2022, two applications were received from the two applications were received. Also, one of the applicants was the petitioner and the other was the respondent number 7. Also, he submits that a scrutiny committee, in accordance with the procedure mandated, was formed by the Gauhati University authorities while issuance of a notification dated 28/7/2025. Accordingly, the college authorities forwarded the application submitted in the matter by the petitioner and the respondent number 7 to the said scrutiny committee. Also, the scrutiny committee, on considering the applications so submitted in the matter, proceeded to hold that the petitioner herein did not satisfy the eligibility criteria as set out in the advertisement dated 29/5/2025, inasmuch as he was found to have not fulfilled the requisite eligibility criteria set out in the provisions of the regulations of 2018. Also, accordingly, the scrutiny committee recommended the name of the respondent number 7 for recruitment, for appearing before the selection committee for recruitment against the post of principal as advertised, while the advertisement dated 29/5/2025. Also, Mr. Chaudhary submits that basing on the said recommendations of the scrutiny committee, the selection committee as constituted in the matter in the college had considered the case of the respondent number 7, and on such consideration, he being found to be suitable for appointment as principal, recommendations came to be made in his favor by the selection committee. Mr. Chaudhary submits that in view of the interim directions passed by this court in WPC number 6681/2025 and WPC number 3018/2025, further process in the matter was kept in abeyance. Mr. Chaudhary, by referring to the It a question, no? Communication dated 1/3/2018. Have I read, said about that communication? Associate Professor, I think I have said. So in the above premises, Mr. Chaudhary submits that the petitioner admittedly not being eligible for being considered for recruitment against the post of principal of a provincialized college, comma, the scrutiny committee's recommendation. The recommendation made by the scrutiny committee holding him to be ineligible for appearing before the selection committee for recruitment against the said post would not mandate an interference from this court. Accordingly, Mr. Chaudhary has submitted that with effect from 2020. First advertisement is 2022. Submits that since the year 2021, the post of principal of the college is lying unmanned, causing great inconvenience in managing the day-to-day administrative affairs of the college, which is now being so managed on in-charge basis. Accordingly, he submits that the petitioner being demonstrated to be not eligible for recruitment against the post of principal of a provincialized college in the state, comma, on account of his lack of the requisite eligibility criteria laid down by the UGC, comma, this court would be pleased to direct the respondents to take the process of recruitment to the post of principal of Mankachar College to its logical conclusion, and for the purpose would be pleased to vacate the interim directions. Mr. P.J. Fukan, Learned Counsel for the Gauhati University, appearing on behalf of the scrutiny committee as well as the selection committee, not the scrutiny committee only.
Selection committee, minute. Respondent number 5 and 6.
Scrutiny committee. First is the scrutiny committee, second is the or is the both the same?
No, minute.
Who are different?
Two entities.
Appearing for the respondent number 5 and 6. Submits that at the outset submits that the petitioner in the writ petition has not brought on record any materials to demonstrate that he had cleared the net and or he had acquired the net and or slate qualification. It is submitted that for appointment as an assistant professor, it is mandated that a candidate must have net / slate qualification and or should have a PhD degree. The petitioner is found to have not acquired the net and slate qualification, but had acquired the PhD qualification in the year 2014, more particularly with effect from 4/12/2014 from the Gauhati University. Mr. Hogan submits that the eligibility of the petitioner to hold a post of assistant professor would arise only with effect from 4/12/2014 when he had acquired the PhD degree. Mr. Pukan submits that the period of service rendered by the petitioner prior to that as an assistant professor would not mandate consideration for his further advancement to the post of associate professor and also for a recruitment against posts of principal in a provincialized college also. Mr. Pukan, by taking this court through the service particulars of the petitioner, initially at Mankachar College and thereafter at Shillong Engineering and Management College, so and so, submits that the said service admittedly, said service as an assistant professor of the, projected to be as an assistant professor by the petitioner was actually as a tutor in Mankachar College and the service at the Shillong Engineering Management College, Jorabhat, admittedly cannot be treated to be as of assistant professor in as much as during that relevant period of time, the petitioner did not have the eligibility to hold the post of, to be recruited against the post of assistant professor. Mr. Fukan submits that the provisions of the UGC regulations are applicable to all institutions of higher education, to all higher education institutions, irrespective of the fact as to whether the said institutions are government-controlled institutions and or private entities. Accordingly, Mr. Fukan submits that the services of the petitioner in Shillong Engineering and Management College, Jorabhat, as an assistant professor must be assessed in the light of the qualifications set out for recruitment against a post of assistant professor. Mr. Kan Sapara further submits that the petitioner has contended that he was initially recruited as an assistant professor in the downtown university, a university covered by the provisions of the UGC regulations with effect from One 2010 as a assistant professor. So, Mr. Fukan submits that the said continuance of the petitioner as an assistant professor in downtown university with effect from 1/7/2010 is also required to be held to be without the requisite eligibility criteria. Mr. Fukan has submitted that the petitioner has thereafter projected that he was promoted to the post of associate professor. Mr. Fukan submits that there is a definite procedure laid down to be followed by universities for upgradation of the services for a recruitment against the post of associate professor existing in a university and or college, either by way of direct recruitment and or by way of career advancement scheme. The documents brought on record by the petitioner only reveals that the petitioner in downtown university was redesignated as an associate professor with effect from 1/4/2018. He submits that the petitioner has not brought on record any material to demonstrate that the procedure laid down either for direct recruitment to the post of associate professor and or a procedure laid down in the UGC regulations, either for direct recruitment to the post of associate professor and or promotion under the career advancement scheme. That's the only two way was complied with while allowing him to function as an associate professor in downtown university. Accordingly, Mr. Fuso. Alternatively, Mr. Fukan submits that even if it is construed that the petitioner was working as an associate professor, considering the fact that he had acquired the eligibility criteria for being recruited as a assistant professor only in the year 2014 on acquiring the PhD degree, the petitioner cannot be held to have satisfied the criteria laid down by in the UGC regulation requiring an intending candidate for the post of principal to be working in a post of associate professor or professor with 15 years of teaching experience. Mr. Fukan submits that the 15 years teaching experience as laid down is a 15 years of teaching experience with the requisite qualification. Accordingly, Mr. Fukan submits that even if the other criteria laid down under
Scale up. Which uses scale up?
with the UGC scale up. Okay. Legal. Qualifications and the scale of pay mandated laid down prescribed by UGC. Also, accordingly, the petitioner cannot be held to have, accordingly, even if the petitioner is held to have fulfilled the other requisite eligibility criteria set out under clause 4, downward 5, dot Roman 5, dot A of the regulations of 2018, he cannot be held under any circumstances to have fulfilled the requisite eligibility criteria, the criteria as set out under clause Roman 2 of the said clause of clause 4, 5A. Also, anything more?
No, my lord.
In the
Covers
above
everything.
background, in the above premises, Mr. Fukan submits that the petition admittedly not having the requisite eligibility criteria, its exclusion from the zone of selection by the scrutiny committee as constituted after the in pursuance as constituted in pursuance to the advertisement dated 25 years ago, 29/5 so and so, would not mandate an interference by this court. Mr. P.K. Decca, Learned Counsel, appearing for the respondent number 7, has adopted the arguments advanced by Mr. K.N. Chaudhary, Learned Senior Counsel for the governing body, and Mr. P.J. Fukan, Learned Counsel, appearing for the respondent number 5 and 6. In addition, Mr. Decca submits that. Mr. Decca also reiterates that the petitioner had misrepresented the authorities as well as this court by projecting himself to be an associate professor with the requisite teaching experience as an assistant professor with effect from 2005, and accordingly was successful in requiring this court to pass interim directions in the matter. Mr. Decca submits that the contention raised by by the Learned Senior Counsel for the petitioner, that the petitioner had also participated in similar recruitment exercises held in other colleges for the post of principal. Mr. Decca, in connection with the contention made by the Learned Senior Counsel for the petitioner, that the petitioner had participated in similar recruitment exercises carried out for the post of principal in other provincialized colleges of the state, submits that the petitioner had applied for the post of recruitment to the post of principal of BN College, Hubri, by projecting himself to be an associate professor with all requisite UGC norms. He submits that the petitioner was called for the interview and he was required to produce certain documents by the selection committee. However, also, he submits that the petitioner, on receipt of the said communication from the governing body oblique selection committee did not turn up for the recruitment process, which also reveals that the petitioner did not satisfy the requisite eligibility criteria for recruitment to the post of headmaster, a principal of a provincialized college, principal of a college. Mr. Decca has submitted that the respondent number 7 fulfills all the requisite eligibility criteria as set out in the UGC regulation and as reiterated in the advertisement issued in this connection, and accordingly prays that the recommendation made in his favor by the selection committee after he was so found to be suitable for recruitment to the post of principal of the college by the scrutiny committee, be permitted to be taken to its logical conclusion at the earliest. Done.
Yes.
Anything left out?
No, no, we don't.
Mr.
Lordship,
A.
only
Chomuha.
petitioner's MPhil that may kindly be son. MPhil obtained
MPhil from?
Madurai Kamras.
Likhit was inside out. Mr. Sharma, Mr. Sharma, Ati Sharma, Learned Counsel for the petitioner submits that although the petitioner did not have an MPhil, but did not have a PhD and or net slate qualification, PhD degree and or net slate qualification, the petitioner had on distance by pursuing a course in the distance mode acquired the MPhil qualification from
Madurai Kamras.
Madurai Kamraj University in the year
2008.
2008. The MPhil qualification as projected by the petitioner to have been having been so acquired on distance education mode, from a university not having jurisdiction to offer such courses in the state of Assam, the said MPhil qualification would be of no consequence. Mara. Mr. Dr. A. Chomu, Learned Counsel, appearing for the Learned Counsel, appearing Standing Counsel, UGC, refers that the UGC, that the norms set out by the UGC in its regulations, including the regulation of 2018, is mandatorily required to be so complied with both by institutions in the governmental sector as well as recognized institutions in the private sector. He submits that the private colleges are required to comply with the provisions of the UGC regulations, holding the force from time to time for the purpose of recruitment to the post of assistant professor till the and also for recruitment against the post of associate professor, either by way of direct recruitment and or by way of promotion. He submits that in the event the recruitments are made in a private institution, he has the eligibility criteria as set out by the UGC in its regulations, such engagements oblique appointments as the experience gained by an incumbent in pursuance to such engagement oblique appointment would not be reckonable for recruitment to further higher posts in other institutions under the UGC. Accordingly, he submits that this court would consider as to whether the petitioner at the time of his initial recruitment and continuance as an assistant professor had the requisite eligibility criteria, had fulfilled the requisite eligibility criteria. He also submits that this court would also examine as to whether the petitioner was promoted to the post of associate professor, was recruited to the post of associate professor either by way of direct recruitment and or promotion after the procedure as mandated in the after his case was considered by a selection committee constituted in terms of the UGC regulations after his case was so considered by a selection committee constituted in terms of the UGC regulations holding the force at the relevant point of time. Mr. Chomuha submits, Dr. Chomuha submits that in the event the petitioner was engaged was appointed and or promoted as associate professor, because the procedure laid down in the UGC regulation, the petitioner would not be entitled to take advantage of such engagement for further recruitment to the next higher grades in other colleges of the state. Yes. No. Do you think I'm going to finish it up like this? I'm not going to finish it up. You have already taken up 1.5 hours of mine. Lekha. Had the learned counsel for the parties at some length. Hearing concluded, registry to list this matter on Kundina Kumbar Monday for Naji dispose koidu. Dispose. But you will get it on Tuesday after the holies only. That much you must give me.
Yes, sir.
After the holies, you will get it. You can apply it today. I'm dismissing the writ petition along with everything. You can apply, but you will get the copies on 1st Tarik. 6th you will. Same idea. Holiday for people like you, not for people like us. Or Mr. Deka or Mr. Fukan, we are always involved. One doctor, much about. You need not study anymore. You are well read.
Most of life.
Yeah, dispose the career. Oh, I would, in view of the orders passed in WPC number so and so, the no further order is called for. I get out dismiss. Yes. Yes, Mr. Dhar, what is the outcome?
My lord will take up this, but after some time. P. Nayak is appearing. He is in the old building, court number 1. He has some instruction, my lord. That is what he told me.
Yes, madam.
My lord, petitioners are working as a regular chokidar, my lord, under the office of this executive engineer, PWD Rural Division, my lord. My lord, they are most senior, my lord. And now, my lord, petitioner prayer for upgradation, they are post, my lord. And seniority list is, my lord.
Is there a provision for upgradation or promotion?
My lord, only upgradation for as per law, my
No, what is upgradation? Upgradation means that the grade 4 post will be taken up as grade 3 post. That is not permissible.
My lord, my lord.
So promotion is permissible.
My lord.
90:10.
My lord.
So you say some juniors have already been promoted.
My lord.
And your cases were not considered. Have you made them party respondents here? Have you challenged those appointments?
Yes, my lord, but my lord, that your lordship dismissed. Thereafter, I have not.
You have not brought them as
Just
party
one-
respondents. Yes, Mr. Dhar.
The case is very simple, my lord. 90-10. 3 posts. 1 gone to compaction department, 2 remains. So, my lord, no scope.
No, but you have promoted.
Promoted. Let her bring this on record, my lord.
It's already on.
My lord, the thing is,
It is already on record. They have filed an affidavit in reply. These are grade 4 post holders. How much law will they know? So when they are before a high court, this high court has to be broad. Now, why were these 2 candidates promoted? Who is projected? Page 36. Who is 35? Who is projected to be junior to them? And these people are before this court from 2013. You're still in service, madam?
My lord, petitioner number 2, my lord, and one was expired already.
One expired.
My lord, I have,
And
my
two?
lord, two is on service, my lord,
Oh, one gone.
my lord.
No substitution.
There's no substitution, but I inform my this honorable court, my lord, for IA, my lord. Amendment
Not
petition.
filed. When did he die?
IA, my lord, IA civil 1362, my lord.
1362 give a
Amendment petition, my lord. Written it.
You withdrew this. You withdrew this appeal. IA
Yes.
closed.
Yes, my lord.
So when did he die? Respond number, petition number 1, when did he die?
My lord.
When did he die, madam?
My lord,
Huh?
he died, but exact date is not.
Any date, Mr. Dhar?
They're in.
Yes. You have your own rules. Assam Ministerial Staff and District Establishment Public Works Roads Department Service Rules,
Yes, ma'am.
2021. That's the rules you follow. Leha. Heard Ms. L. Wajida, Learned Counsel for the petitioner. Also heard Mr. R. Dot, Learned Standing Counsel, Public Works Department, appearing for all the respondents. Ms. Wajida at the outset has submitted that the present petition is being pressed only in respect of the petitioner number 2, inasmuch as during the pendency of the present proceedings, the petitioner number 1 had passed away. She submits that no substitution of the legal heirs of the petitioner number 1 was also made by the petitioner. Also, accordingly, this court would consider the present petition only in respect of the petitioner number 2 herein, Awal Mojid. Also, the petition had instituted the present proceeding, praying for a direction upon the respondent authorities for upgradation of their posts to that of lower division assistant / section assistant. Also, next para. The petitioner number 2 herein was appointed as a regular chowkidar grade 4 post over on 1/1/1994 in the office of in the establishment of the respond number 3, that is the executive engineer, PWD rural roads over division, Dhubri. The petitioner continued to discharge his the petitioner number 2 continued to discharge his duties in such capacities. Also, vacancies having arisen in the post of lower division assistant / senior assistant, The petitioner number 2 submitted representations before the authorities praying for his promotion against the vacant grade 3 posts available in the establishment of the respondent number 3. It is projected that although proposals were prepared for the purpose of promotion of the petition number 2 to the next higher grade post to the next higher post figuring in grade 3, in grade 3 of the service, comma, no final orders came to be passed in the matter, and the petitioner number 2 continued to serve as against the grade 4 post he was originally appointed to. Also, it is further projected by the petitioner that during the pendency of the present writ petition, the respondent authorities had promoted two persons junior to the petitioners in the grade 4 service to the post of grade 3, ignoring the case of the petitioner's hearing. Also, in the above background, the petitioner number 2 prays that his case be also considered for promotion to the cadre of to the post figuring in grade 3 cadre of the service with a retrospective effect, at least with effect from the date his juniors were so promoted. Also, Ms. L. Wajida, learned counsel for the petitioner, by reiterating the facts as noticed herein above, has submitted that admittedly the fundamental right vested in the petitioner for having their petition number 2 for having his case considered for promotion to the cadre of grade to the post figuring in cadre grade 3 of the service was admittedly violated inasmuch as while juniors came to be so promoted, comma, the petitioner's case was not extended with similar consideration. Accordingly, she submits that a violation of the fundamental rights having occasioned of the petition number 2 having occasion, this court would direct the respondent authorities to consider the case of the petitioner for promotion to any of the vacant grade 3 post at the relevant point of time when his juniors were so promoted. Anything more? You know, I miss out. If you have something, you tell me. Okay, think and tell.
Consider.
Think and tell me. Anything you tell me, I'll incorporate it,
Yes.
madam.
My lord, also consider my representation also, my lord. Yes.
Ms. Wajida has submitted that the petitioner, although had not moved before this court, the petitioner submits that the petitioner was regularly approaching the respondent authorities by way of submission of representations, praying for his promotion praying for consideration of his case for promotion to the next higher grade of the service. However, such representations had also not evoked any response from the respondents. Mr. R. Dhar, learned counsel for the petitioner, submits that the promotion from the cadre of grade 4 to grade 2, grade 3 was so regulated by the provisions of the Assam Ministerial District Establishment Service Rules 1967. He submits that in terms of the provisions of the said rules, posts in grade 3, 10% of the posts of grade 3 is to be filled up from incumbents in the grade 4 of the service. He submits that given the cadre strength of the post of junior assistant and section assistant in grade 3, 3 posts had worked out for promotion. 3, na?
3, my lord.
3 posts had worked out for promotion from grade 4, from incumbents in the grade 4 cadre to the post of junior assistant in grade 3. He submits that one of the posts involved was filled up by appointing a person on compassionate grounds. The other two posts were so filled up by two other incumbents working in grade 4 posts who were found suitable for such promotion. He submits that the petitioner, by way of filing an additional affidavit, filing an affidavit in reply, has contended that the two persons so promoted to the post of junior assistant were junior to the petitioner, number 2 in service. He submits that the said contention having been raised, the challenge to the promotion effected in respect of two juniors to the post of junior assistant was not brought on a record. He submits that the petitioner had filed an interlocutory application praying for amending the writ petition. However, the said interlocutory application on a prayer made by the petitioner was permitted to be withdrawn by this court by order dated 16/7/2025, and thereafter no fresh application has been filed in this connection. In the above premises, Mr. Thor submits that the appointment effected in respect of two persons to the promotion effected in respect of two persons to the post of junior assistant in the year 2016 being not permissible to be interfered with by this court at this stage. The prayer made by the petitioner for a retrospective consideration in her case would not mandate an acceptance. Right? Anything more?
My lord. And
Mr.
Moreover, my lord, this order, my lord, in the affidavit in reply, my lord, they are not made party in this case.
Not challenged, not party.
Okay.
Mr. Dhar has further this 21 is still in operation.
Yes, yes.
Mr. Dhar has submitted that the earlier rules of 1967 was amended in the year 2016. 16, na? Graduate?
Graduate, yes, my lord.
16. 2016.
16.
And for promotion from grade 4 to grade 3 of the service, it was mandated that the incumbent must be a graduate. He submits that the petitioner, number 2 in the present writ petition, admittedly is not a graduate. Also, he further submits that for the post figuring in the Assam Public Works Department, the Assam Ministerial Staff District Establishment, bracket, Public Works Roads Department Office, bracket over, Service Rules 2021 was notified, wide notification dated 19/7/2021. He submits that in terms of the provisions of the said rules of 2021, for promotion of a member of grade 4 service to the post of junior assistant, he is required to possess a bachelor's degree or equivalent examination from a university recognized by the state of Assam, by the government of Assam. Accordingly, he submits that the petitioner not having the requisite educational qualification, his case would not be mandated to be so considered for promotion against an existing promotion to the grade to post figuring to grade 3 in the event any vacant post for the purpose is so available as on date. Accordingly, he submits that the writ petition would mandate to be dismissed. I've heard the learned counsel for the parties and also peruse the materials available on it. The present writ petition is pending since the year 2013. Also, the grievance of the petitioner was to the effect that their cases for promotion was not being taken. Their cases for promotion from grade 4 to post figuring in the grade 3 cadre of the service was not being considered. It is seen that during the pendency of the present proceedings, the respondent authorities had undertaken an exercise for promotion from the incumbents in the grade 4 cadre of the service to the post figuring to the available vacancies in the grade 3 cadre of the service in the establishment of the respondent number 3, wherein the petitioner number 2 is so working. It is seen that in pursuance to the said exercise, 2 incumbents, namely Amarjyoti Kormakar and Tomuna Rabha, came to be promoted to the post of junior assistant while issuance of office orders, both dated 31/2016. It is projected by the petitioner that both the incumbents who were so promoted while the said order dated 31/2016 were junior to them in the grade 4 service, in the grade 4 cadre by their respective dates of initial engagement. The petitioners, having brought the said aspect of the matter to the notice of this court, it is seen that no steps were taken to assail the said orders dated 31/2016, which had been projected to have the effect of promoting juniors to the petition number 2 to the cadre of junior assistant ahead of him, without considering his case. Further, it is seen that the said 2 incumbents were not also arrayed as party respondents in the present petition. Although the petitioner had instituted an interlocutory application being IA(C) number 1362/2025 for amendment of the writ petition to bring on record the said development taking place in the matter, it is seen that the said interlocutory application on a prayer made by the learned counsel for the applicant, that is the petition number 2, was permitted to be withdrawn by this court while an order dated 16/7/2025. Thereafter, no application has been instituted for impleading the said juniors who were promoted while the order dated 31. Accordingly, the court is of considered view that the promotion as affected in respect of the respondents number, in respect of so-and-so, Ruta Nam Dishunopon, in respect of so-and-so, while orders dated 31/2016 would not mandate an interference. Having drawn the said conclusion, this court would now examine as to whether a direction can be issued to the respondent authorities for considering the case of the petitioners for such promotion against vacancies that may be existing as on date and that would arise in the near future. It has been brought on record by the learned counsel for the respondents that the service conditions of incumbents in the district level establishments of the Public Works Department is now governed by the provisions of the Assam Ministerial Staff District Establishment Service Rules 2021. Also, the service is, in terms of the provisions of Section 3, the service is held to consist of 3 cadres, and they are A, head assistant, semicolon, B, senior assistant, and C, junior assistant. Also, the manner of recruitment to the post of junior assistant is provided for under the provisions of Rule 5, bracketed 3 of the said rules of 2021. Rule 5(3), bracketed C, mandates the procedure for promotion to the post of junior assistant from the cadre of grade 4 of the service. Also, the conditions, the eligibility criteria set out in the provisions of the said rules for such promotion requires the incumbent in the grade 4 cadre to possess a bachelor's degree and an equivalent examination from a university recognized by the government. It also requires the such incumbent to be to have rendered minimum continuous service of 7 years and to be capable of typing in computer and to have sufficient working knowledge of computers. The petition in the present, petition number 2 in the present with petition, comma, is only higher secondary, only has an higher secondary qualification and admittedly has not acquired a degree qualification. Accordingly, in view of the provisions of Rule 5, bracketed 3, bracketed C, bracketed 1 of the Roman 1, small, of the said rules of 2021, the petition in under no circumstance can be considered for promotion as on date to the cadre of to the great service of the cadre, more particularly against the post of junior assistant. It is also to be noted that the petitioner in all probability would also not be entitled to be considered for promotion against the technical post of section assistant, inasmuch as it has not been demonstrated that he also possesses the requisite qualification for such promotion. Also, in view of the above conclusions reached by this court is of the considered view that the claims made by the petitioner in the present writ petition would not mandate an interference, would not mandate an acceptance. Also, accordingly, the present writ petition is held to be devoid of any merit, and the same stands dismissed. However, there would be no order. Sorry, can't help it.
Oblige, Your Lordship.
I'm good with it.
Oh, fine. Yes, Mr. Naik, what is the?
Lordship, in this matter, I received some photocopies, Lordship. In fact, Lordship, initially the file was sourced in the office of the Nigeria, Lordship. Subsequently, it is found at the office, Amguri office, Lordship. That only 3 documents has been furnished, Lordship. It reflects, Lordship, from the division itself, Lordship. When the file was forwarded to the department, Lordship, his date of birth is mentioned as 1956.
In the service book, it is 1969.
Accordingly, Lordship, authority approved his date of birth as
What is the document you have? When was your service book opened? When was the date of opening of the service book?
after regulation, definitely, Lordship.
It is after regularization, Lord.
Date to go.
First entry was of 30th of June 2005.
Okay. Yes, Mr. Haloy. What is the basis of this 31/12/1969?
My Lord, at the time of regulation, I submitted my school certificate, and that school certificate says my date of birth is 31/12/1969. And that school certificate has been attached in the service book also by the authority. And
No, that school certificate that is there,
yes, my Lord.
where is the
That page
material to
20.
show that you had produced this school certificate at the first instance also? (1969), that when you joined as a master roll worker. Now, master roll is master roll.
Right.
But while you join, there is a procedure that they record your details. There is a form that while they record your details in the master roll, they record this form. And in the form, you have to declare a date. Now, you declared it as 56. Naturally, it cannot be a fanciful thinking of some engineer there. You declared it as 1156, or it was taken as 1156. If it is 1156, The date when you were engaged as muster roll, you are above 18 years.
my lord.
But if we take it as 1969,
Then it
you
is
are
above
below
15.
18 years. Then there has to be a further specification that there is an urgency. That is why we are taking this boy. You're not a man at that point of time.
My lord, normally what I have
Normally,
also
you will
experienced,
have
my
to
lord,
have
for exigencies
clarification.
of work, people are being picked up
No, no,
for
no.
master.
Where is your plea to that effect, Mr. Loy? Where is your plea to that effect?
That in
There
reply,
is no
I, in
statement
reply, I
in the
have stated,
petition.
in reply,
You should have visualized that position and covered it up.
in reply affidavit, I have stated that, my lord.
What, where? Let us see.
In reply affidavit. That paragraph 4 starts from page 35, my lord. In page 36, the last line, it is pertinent to be mentioned here that at the relevant point of time, people were picked up as master worker for the exigencies of work without strictly following the SBAR.
That
But
is
that was
wishful
at
thinking.
that relevant point of time, what we also seen in the
Okay.
village is
Now you were supposed to retire in when?
2029.
And you have been retired in?
No, I am still working, Lord.
Okay, you will retire on, otherwise you will have retired on?
29.
16.
No, that
2016.
as per that communication, 16.
So what we do is, we retire you in 16. Whatever you have served, being served in pursuance of directions passed by this court, they will not touch the benefits you have drawn. Now I think you should take some rest in the house. Pension, 2016.
6. Right.
My Lord, what I'd like to submit, the document I have not gone through.
No, nothing is there. I'm also
Lord,
not going.
my school certificate.
Oh,
has been-
Mr. Nayak from somewhere, he has picked up these documents.
No,
Give it
I
back.
am not. I am not disbelieving that. Lord.
I'm not even looking into it.
But thing is that, my Lord, so what I'd like to propose that 14 to that age, it was about 15 when he was put in. It was about 15. So for calculation of pension, if that 15 to 18 could be because you know,
Cannot be.
he has served and from the record, although it is submitted in affidavit also, they have not stated anything. Only their stand is that in 14 years, no one could be engaged as per Article 24, but that is
Because,
misunderstood.
see, yeah, let me do one thing. Let me tell you. You have not submitted an application for correction also.
That is
There
my
was a
that is my point, Lordship.
What is
Lordship,
there?
for regularization, we have no rule as such. Accordingly, when their services were regularized,
That
some
notification shows that it is 56.
yeah,
He has not gone to, some executive engineer has done
that
it.
is what I'm submitting, Lordship. Some conditions were set by the authority. One such condition was discrepancy if found in list of so and so master may be referred to the respective control branch of finance department. So without the concurrence of the finance department, no such discrepancies could have been rectified by the authority himself, Lordship.
My Lord,
He should have forwarded it to the authority,
Date of birth is 1156.
Lordship.
but that is nowhere recorded, my Lord. In service book, it is recorded.
No, why
31,
did you not
1969.
dispute this 34/2016
Lord,
recording?
my statement is there in the petition also that I approached the executive engineer. He assured that it
No,
would be
this cannot
corrected.
be done by the executive engineer. This has to be done by the government.
Lord, what has
He
been
could
done?
not have done it. He could not have done it on his own.
I am under impression that as service book has been opened after
Okay, fine, you have
regularization.
served enough. Now you take your chance in the appellate court.
Lord, if we go by the service book, it is not on my part. It is opened by the authority and they have gone through all the relevant documents.
We'll deal with that. Two o'clock we'll pass the.
Lordship, I have another matter.
Please, no, need not be here. None of you be here. Having a slight dictating two things, I'm having a slight throat irritation. That's why I'm not dictating.
Almost.
Mr. Hello, we will protect you. Date of retirement, you will get your pension. But the benefits will be given from, timing is also very nice. From 1/3/2026. From tomorrow onwards, you are getting your pension. But till today, you will not get pension because that salary we are protecting. And rest, you can walk next door.
Obliged, Lord.
Take rest.
No,
Let your family, children now look after you.
in fact, my lord,
Enjoy
his
your
actual
retirement life.
age is that 69. My lord,
14.
Working since 1984.
84.
Now
Ma'am,
this is,
Mr. Aloy,
this is
I think you should
26.
take rest now.
42 years already there.
No,
And
14,
that calculation is also there. So 84, maximum is 42.
Yes.
So 84, 42 would be 2012.
Lordship.
After 2000, how can you work more than 42 years?
84, 94.
There is a
it is
decision.
up to 60,
There is
either
a decision
60
of
or
court.
42 years.
42 years, yes.
either 60 or
10, 18, so
whichever
no,
is
60 years,
later.
Kitna? 42 plus 18 would be
60.
60, huh?
Ah.
Yeah, so 84
42
plus
84 plus
80.
24.
Sir, 84, it would be 16 plus
No.
26.
No, if he,
It is
it
42.
is assume that he has joined service
18
at the
years.
age of 18.
Ah.
Then up to 60 lordship, it is 42 years. So a person cannot be accepted to be in job lordship more than 42 years. That is the idea, lordship.
No, that is either or, whichever is later.
Oh, you have served enough. Now I think you should take some rest. Enjoy your kids, and, grandchildren and all.
But if you will continue till 29, then it will be better for enjoyment.
That, let us have that post manned by some youngster now. Employment, let us give it to some young people. You move out, a youngster comes in. Another family is elevated out of poverty. That's what we plan. Okay, fine, Mr. Alice.
Well,
2 o'clock we'll pause.
Well.
Obliged.
And you are getting your pensions from tomorrow. Salary stopped today. Pensions will come. And till the pension proposal is not finalized,
Finalized.
give him a
Provisional.
provisional pension.
But it will be calculated as per the,
Calculated as 1416.
as per the pay he was getting in 2016.
116. This period, no pension because he is getting the
Getting
salary, we are protecting it. From tomorrow onwards, he is entitled to pension, but that will take time. So issue a provisional pension order till the AG authorizes to him the normal pension.
Lordship. Lordship. Obliged, Lordship.
Lordship has no occasion to represent him.
Okay.
Mr. Tobim is my lord.
Thank you.
I am starting with a charge is not definite, my lord. To that effect, I can charge will have to be definite, my lord. I am giving a judgment of the Honorable Supreme Court, my lord. Passed in Churat Chandra Chakraborty as a state of West Bengal, 1970.
So you say the charge is not.
Charge has to be proved. What they have proved is not the charge, my lord. Statement of allegation also same with the charge, my lord. And next thing, the cumulative effect part is not on Rule 7, my lord. The punishment imposed is not according to Rule 7, my lord.
We'll go one by one. You come to
My-
page
my-
29.
Can I give it, my lord?
We'll take it, but let's see the facts first.
The petitioner was appointed as a to the Assam Public Service Commission as a junior grade. He was appointed.
No. You come directly to page 29.
29.
Ah.
Page 29 is the charge sheet, my lord. 29 is the charge sheet.
Mr. Goswami, we'll have it in an interactive manner.
Lordship,
You
Lordship.
take out page 29.
Yes, Lordship.
This is the charge, my lord.
Forget, you be an advocate,
Lordship.
be a general person.
Lordship.
Talk be, talk be,
Lordship.
the officer. Now come to one page, charge number, allegation number 1.
While you were
Hmm.
posted as a sub-divisional police officer, Gosaigaon under Kokrajhar district, since the
Break out the
break out the
violence.
communal violence of Kokrajhar district, you were found evasive and untraceable
Evasive and untraceable
at the time of
need.
need and negligenting your duties as the PO of the sensitive Gosaigaon subdivision.
Now tell me, what is the time frame involved here?
Yes.
When he was date period, nothing is there.
That's what time period.
Just a minute.
So this allegation you have led. What is the time period?
Period is there, Lordship.
Where is that period?
No, that period, that incidental period, Lordship. That was
When was the incident?
no. Lordship, communal violence is there.
When? Which year? Which date?
Yes, Lordship. That Lordship.
Now come to the next.
Lordship. No, that
Now you come to the next one.
Lordship.
Your unauthorized absence from duty. Period. Which period you were unauthorizedly absent?
That's true, Lordship. That is not specific.
Now come to 5. Your cowardliness in violent violation of the spirit and letter. Cowardliness in what context?
Lordship, Lordship, there was a communal violence, Lordship. That was
Kokrajhar, there were many incidents.
No, Lordship, that year, I think the year was given, Lordship. Okay. No, that Lordship, impliedly it was given, Lordship. It is given, Lordship. That while you were posted, yes.
When a plea is taken that a charge is vague.
My lord.
When a charge is vague, a plea is taken as a charge is vague.
Okay.
Why is it so taken?
I do not understand the lordship.
Means you said the charge is vague.
Chances with means?
Charge is clear.
Charge is vague.
Vague.
Yes.
So why is
Charge
that?
is not definite, my lord.
Charge is not
definite. It should be definite,
from
my
which point of view?
lord. My lord, I can show you 9-2, my lord.
No. But let us forget 9-2. Mr. Bhattaji is there. 9-2 I am not. I want Mr. Bhattaji's. Now, vagueness.
When something
not
is
definite,
alleged, my lord.
Not definite. From
When
the point-
something is alleged, my lord. You are not, you are absent, you are not there, at which time, on which date, everything is, every data has to be given, my lord.
No.
So that I can give a reply,
Why? Because you have to give a reply.
my lord. That
So
is the
that you
reason,
can understand.
that is the reasonable opportunity, my lord.
You can understand what is the allegation against.
Yes, my lord.
Right?
Yes.
So a pinpointed reply can be given.
Given.
I don't find that you were in any manner prejudiced in giving the reply. Page 34. You understood the charge in the context the authorities wanted you to understand.
That is not the thing, my lord.
Page 34, charge 1. Reply to the charge.
You stick to that page.
Lordship.
I'm going with Mr. Bhattaji in the second page. You be there. Vagueness. Lordship. I want
33
an
onwards.
answer from you.
33 onwards, my lord.
34, basically.
On
33 does not say anything about vagueness of charges.
4, my lord. 4. On the other hand, on the basis of the base functionary report of the Superintendent of Police, Kokrajhar,
That is
the
just a-
Additional Director of Police has been pleased to still move a vagueness of addition of few adjectives and detriment to the career of a young budding.
beauty of the English language. But you come to charge number 1. You have met it very. You have taken it on the chest.
No, I have denied the every charge.
No, no, but you have not denied that you have not understood the charge.
I have carrying some mobile phones.
You say I was ready, violence.
I
happened.
am
You are-
discharging my duties, my lord.
Mr. Bachaji,
My lord.
the allegation is say the earth is oval. But
The
you
allegation
understood
is
that
there,
this
I am
allegation
absent.
is pokrachar, violence. I must explain what I did. You did it.
When
If you had said, I didn't
my reply
understand,
is that I was present.
you were
What-
there. That is on merits.
I
That
was
is on merits.
I am all along the in
Mr.
the
Bachaji,
entire
that is
period.
on
I am
merits.
present,
That is on merits.
my lord.
We'll come to that. But your case is technical. Say that charge I can't understand. Vague, indefinite. That
My
is not there.
charge has to be proved, my lord.
Okay, now that is the third. So this is gone.
Charge has to be
So,
proved.
Chair,
So they have to give me a pinpointed charge so that I can reply at when, at what time, and on which date I was absent. That
Mr.
was not given, my lord.
That is the third stage. Now we are allegation vague, but you have understood the allegation to the point of it. You have made beautiful replies, denying it.
Yes, my lord, I have denied it. No,
Okay.
nothing has been
That
given.
is on merits. Now come to the findings.
Ending as 43, my lord. Without
What is
taking
the
my
perversity here?
perversity is that I have already paid 52, my lord. Lordship may say pay 52. I want to examine my defense witnesses in the interest of justice and fair play.
That was not allowed.
That was not allowed. That was not allowed. Even the GD entry number 1 and 3 also not taken into record, my lord. Only 2 has been taken.
Page 44, last paragraph. From where did they get it?
Last,
Paragraph, page 44.
this changes of
The charges.
this was it is yes changes.
Changes, okay. We'll
Charges of evading and being untraceable from 27 to 12 to 23/7, except in the night of his own reasonable right, reasonable doubt. So this is not the charge, my lord.
The charge stops charges of evading and being untraceable. The charge is stopping.
This
here.
is not the charge, my lord.
Bachaji understands it in a very high level. Let this court also understand it
My
with
lord,
that
my
level.
lord. Lordship is
The,
understanding very
the
well.
charge of evading and being untraceable is the show cause.
My lord,
The rest part is not there in the show cause.
my lord.
That is your case. You say that you have proved something which was not alleged.
My lord, another thing I am showing, my lord. Fourth, keeping in view all the aforesaid facts clear that delinquent could not produce any document.
Okay. What are the decisions?
My lord, another thing is there, the cumulative part. Cumulative part is not there, my lord. Only they can stop an increment, but it cannot for cumulative effect, my lord, because Rule 7 does not say that, my lord. Rule 7 they can only.
There is a penalty order.
My lord?
Penalty order, page.
Penalty order at 58. One increment with cumulative effect. Cumulative effect part is not there, my lord, in the rule. Rule 7, my lord.
Now, Mr. Bachaji, because of this penalty, any promotional
No,
deprivation, nothing.
Nothing.
We'll modify this to Without cumulative effect. Let
Well-
it go. We'll modify it to without cumulative effect.
Lordship has to set aside the entire thing, my lord.
Appeal preferred, nothing.
Appeal preferred dismiss after 7 years, my lord. On the insistence of this honorable court, my lord. That is why the writ petition have to be amended.
Yes, Mr. What are the decisions you want to rely on?
Surat Chakrabarti, my lord, number 1.
Citation?
Citation 1973 SCC 548.
73, 70,
70. Bracketed 3
CC.
SCC 458. Surat Chandra Chakrabarti. Another 95-1 SCC 332. Transport Commissioner Madras 5. Rule 9(2) is mandatory, my lord. That is violated to some judgment on that also, my lord. 2 judgments. Total 4 judgments I have given, my lord. That is the reasonable opportunity is not afforded, my lord. My case is. In 1970, Surat Chakrabarti, it is para 56, my lord.
Yes, Mr. Goswami. Where do you get this conclusion from? Page 44? This is not a charge.
Yes, Lordship.
Last
Page
paragraph.
44, yes, Lordship. The charge of evading and being untraceable.
That is the charge.
Yes, Lordship.
But where is the other part coming from? A specific date
Yes, Lordship.
coming from.
Lordship, this charge was issued on 18 May 2013. Now, first, while you were posted as SDPO Gusaigaon under Kokrajhar district, since the breakout and communal violence, it means the period was given while he was on duty. That was admitted in his so-called reply.
Okay, we'll take it up at 2.
Yes.
Mr. Vatsaji, you have done it. You have finished. We'll hear it and close it also. Yes, Mr.
My lord, I beg to mention item number 8 because I'll seek some time, my lord, and because of that only he will be waiting.
Why are you seeking time? We were supposed to finish it up today.
Yes, I need some more time, my lord,
Why?
to examine the issue. I could not.
Tentative view. We are not sending back the repetition. Tentative view. We are contemplating directing him to file a appeal there with invoking section 14 of the Limitation Act. This period which he spent here, we'll ask the tribunal to invoke. Tentatively, that's the view. You can have your view on that. When? If that is permissible, you can make your submissions. Not permissible, you can make your submission. I'll invite that.
No, my lord, if that view, tentative view is made final, then I'll not make any submission.
that the matter is going back,
Yes,
you agree to that?
Yes, yes.
Lordship, matter is going back, Lordship, this petition can be treated as
No,
there, because
That,
because
that,
of the fact,
no,
Lordship.
no, that will create problems for you. You file a fresh criminal election petition there. We will direct the trial court. He is also agreeing to that, to condone the period of delay, because at the time when you approached this court, the tribunal was not there.
Yes. Lordship.
And I'll also note that in the order sheets till the other day,
Yes.
this aspect that there was a tribunal already was not brought to the notice
Yes.
of this. So in that view of the matter, we will direct that this is closed, giving you liberty to approach.
Yes, Lordship.
The delay
Yes.
will be condoned by them by invoking section 14 of the
Yes, Lordship.
Limitation Act.
That is also there, Lordship, in our, in Lordship, educational tribunal cases, the
The
educational.
education tribunal
these-
cases, the rigors of the Representation of People's Act is not coming.
Yes, Lordship.
And when you have somebody like Mr. Abedin appearing from the other side,
Lordship.
and I send this petition, he on the first day will say, affidavit is wrong, this is wrong.
Exactly, exactly,
Ah.
exactly. No, I would have apprised this court. I would not have played
No,
that
no.
game. I'm
Because
saying,
that is not possible.
or possibly over here, my lord, that another thing your lordship is aware than the
When
election
he is
petition.
agreeing to that, what is your harm there? We'll also agree. We'll
Yes,
record
yes,
your
yes,
con-
yes, yes, yes.
Lordship.
Lekha.
Lordship, so far as 1 and 2 is concerned, we may be allowed to withdraw
Huh.
With liberty.
What is the limit?
What is your problem? You are having some.
No, no, no. I think
Come back at 2. We will hear Mr. Bhachaji for Mr. Goswami for some time, and then we'll take up your, and we'll dispose it of. Iftari is by 4 only.
No, 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 not for iftar. I thought for some more research.
Itu kata sir.
So can it be on another date, my lord?
We had asked them for some instructions. Have they
Yes,
got the
ma'am.
instructions?
Yes, my lord. He said, my lord, do whatever in the affidavit. I just talked to him, my lord.
On the prayer of Miss N. Soike, Learned Counsel for the petition registry to list. When do you want it, ma'am?
He did, my lord.
No, you give me a
Next
date,
Friday.
convenient to yourself.
Date, my lord. Mm. It is on 10th of March. Tuesday.
On 10/3/2025. 26. Prayer is not objected to by Mr. D. Mushahari, BC Mushahari, Honored Planning Council, BTC. Accordingly, registry to list this matter again on 10/3/2025.
As far that, yes. Obliged, my lord.
Obliged.
Please, your lordship. Lordship, I'm taking your lordship's indulgence for to mention a small thing. Lordship may remember on Tuesday, lordship has done that CAV. So I'm just giving the right short notes, but my lordship, while hearing, we have given the case law, so only the.
Yes.
Lordship, in page 29, Roman 1, number 1, Lordship, while you were posted, Lordship, here the period, although the definite dates were not mentioned, the period was mentioned, Lordship. And that was also clarified by the petitioner himself in his reply. Clarify all the periods. And thereafter, Lordship, the evidence were taken, Lordship, and the charge, this charge were established, Lordship, in the report, Lordship, in the findings, Lordship.
You were the SDPO.
Yes,
At
as
that time,
the prudent officer of the department, Lordship.
Anything more?
No, Lordship, this is clear, Lordship.
Heard Mr. D. Bhattaji, D. N. Bhattacharya, Learned Counsel for the petition, also heard Mr. J.K. Goswami, additional senior appearing for the state respondent. The petitioner in the present proceeding has presented a challenge to an order dated 23/3/2018 issued by the disciplinary authority, imposing upon him a penalty of withholding of one increment with cumulative effect in pursuance to a departmental proceeding instituted against him in the matter. So the petitioner has also assailed the inquiry report submitted, which had led to the passing of the impugned order dated 23/3/2018, along with the order passed by the appellate authority upholding the impugned order dated 23/3/2018. The petitioner, while working as the subdivisional police officer to Saigon, basing on certain allegations relating to the discharge of duties by the petitioner during the period when communal violence had broken out in Kokrajhar district, he came to be placed under suspension. With effect from 26/7/2012. The petitioner was thereafter reinstated in his service with effect from 7/10/2013. Also, prior to reinstatement of the petitioner in his service, a departmental proceeding was instituted against the petitioner by way of issuance of a show cause notice dated 18/5/2013, wherein 5 allegations came to be leveled against the petitioner, which all pertain to the period when the petitioner was functioning as the subdivisional police officer, Saigon. The petitioner submitted his show cause reply to the said show cause notice dated 18/5/2023, on 29/5/2013, and therein by highlighting the vagueness with regard to the allegations leveled against him, proceeded to submit his clarifications in the matter and also denied the allegations so leveled against him. Also, being not satisfied with the show cause reply so submitted in the matter by the petitioner, the disciplinary authority of the petitioner proceeded to direct for holding of an inquiry in the matter, and for the purpose appointed a presenting officer and appointed an inquiry officer and a presenting officer. Also, the petitioner participated in the inquiry. Also, on conclusion of the inquiry officer submitted his report on 6/4/2017. Also, a copy of the said report was forwarded to the petitioner by his disciplinary authority wide communication dated 11/4/2017, requiring the petitioner to file his representative thereon. The petitioner thereafter submitted a representation dated 27/7/2007, dealing with the findings recorded by the inquiry officer in his inquiry report dated 6/4/2017. Also, upon submission of the said inquiry report, the disciplinary authority of the petition considered the same in the light of the representation submitted by the petitioner and wide order dated 23/3/2018. Proceeded to impose upon the petitioner a penalty of withholding of one increment with cumulative effect, with effect from the date of the next increment due to the petitioner. And accordingly, further, the period of suspension undergone by the petitioner with effect from 26/7/2012 to 7/10/2013 was also directed to be regularized as on duty. Accordingly, the departmental proceeding instituted against the petitioner came to be closed. The petitioner, being aggrieved by the penalty as imposed upon him, preferred an appeal before the appellate authority on 18/4/2018. Also, the appeal having remained appeal not being considered and disposed of after a reasonable period of time, the petitioner approached this court by way of instituting the present writ petition. Also, during the pendency of the present writ petition, the appellate authority, vide an order dated 12/8/2025, proceeded to consider the appeal and dispose of the and reject the contentions and reject the same, and thereby uphold the penalty as imposed upon the petitioner by his disciplinary authority. Also, the appellate order having been furnished to the petitioner, he amended the present writ petition and thereby presented a challenge to the said appeal. Appellate or presented a challenge to the order of the appellate authority. Full stop. Subpass. Mr. D.N. Bhattacharjee, learned counsel for the petition, after reiterating the facts as noticed herein above, has at the outset, by taking this court through the allegations leveled against the petitioner in the show cause notice dated 18/5/2013, has submitted that a perusal of the said same would reveal that the disciplinary authority, while proceeding to level allegations against the petitioner, no concrete particulars were so disclosed and the allegations level were vague to the core of it. He submits that the provisions of Rule 9 bracketed 2 of the Assam Services Discipline and Appeal Rules 1964 mandates that the disciplinary authority is required to frame definite charges on the basis of allegation on which the inquiry is proposed to be held. He submits that a perusal of the allegation so level would reveal that no definite allegations with requisite particulars came to be leveled against the petitioner, and the allegations are vague to the core of it. Accordingly, he submits that an inquiry basing on such vague and indefinite allegations would not have been maintainable against the petitioner. Mr. Bhattacharjee has submitted that after the show cause was received by the petitioner, he, after highlighting the vagueness with regard to the allegations leveled against him, had dealt with the allegations leveled by basing on the steps taken by him while working as a SDPO Gosaigaon during the violence that had erupted in the area at that relevant point of time. The petitioner, Mr. Bhattacharjee, submits that the petitioner had brought on record all requisite materials disclosing the steps taken by him in the matter, which would reveal that the petitioner is not guilty of not having taken any step for containing the violence that had erupted at that relevant point of time. Mr. Bhattacharjee submits that the inquiry officer submits that an inquiry having been directed, the petitioner had participated in the said inquiry. However, on conclusion of the inquiry, the petitioner in the said inquiry was subjected to a prejudice inasmuch as the petitioner's prayer for adducing defense evidence witnesses was rejected by the inquiry officer, which is also recorded in the which is also mentioned in the statement recorded by the petitioner herein. Further, Mr. Bhattacharjee submits that the petitioner was denied of an opportunity to cross-examine witnesses. Mr. Bhattacharjee submits that the petitioner had specifically required the respondent, the inquiry officer, to permit him to cross-examine Sri Jitmal Dole, IPS, who had deposed in the inquiry. However, such request of the petitioner was contended to have been rejected by the inquiry officer. Mr. Bhattacharjee full stop. Mr. Bhattacharjee further submits that the non-consideration of the petitioner to adduce defense witnesses and documents, as well as a refusal to allow him to cross-examine one of the vital witnesses in the inquiry, naturally has caused a prejudice to the petitioner, and the findings recorded by the inquiry officer under the set circumstances would not mandate an acceptance from this court. Also, Mr. Bhattacharjee, by taking this court through the inquiry report, has submitted that the inquiry officer, after discussing the evidence, after noticing the evidences coming on the deposition of the departmental witnesses, had proceeded to record his evidence, his findings basing thereon. While nothing material is contended to have been brought on record against the petitioner, the inquiry officer had recorded a finding to the effect that the petitioner could not produce documentary proof of his physical presence in his jurisdiction between 20-7-2012 to 22-7-2012. He submits that the said finding recorded by the inquiry officer is to be viewed in the light of the refusal of the rejection of the petitioner to adduce documents and additional and defense witnesses. What's your case?
Ready to the charge.
That will come, but this is one of the bases. If further submits that the show cause notice having not specified the period during which the said allegations were leveled against the petitioner, and the same being relatable in the charge in the show cause to the entire period when the petitioner was functioning as the SDPO, Kusaigaon, the specification of a date by the inquiry, of a period by the inquiry officer in the inquiry report, during which the petitioner was alleged to be not present in his jurisdiction, is clearly uncalled for and would not mandate an acceptance. He further submits that the inquiry officer had recorded a categorical finding to the effect that the petitioner was evading and remained untraceable with effect from 27-2012 to 23-7-2012, except the night of 23-7-2012. Mr. Bhattacharjee again reiterates that the said finding recorded by the petitioner is beyond the charge so framed against the petitioner, and accordingly the same would not mandate an acceptance. Mr. Bhattacharjee submits that although the petitioner in his representation preferred against the inquiry report had brought on record the inconsistencies so existing in the inquiry report submitted by the inquiry officer, the disciplinary authority, while proceeding to pass the order dated 23-3-2018, had not considered the same in its proper perspective, and accordingly the charges leveled against the petitioner was held to have been established, and a penalty of withholding of 1 increment with cumulative effect came to be imposed upon the petitioner. Mr. Bhattacharjee has made an submission, has also submitted that in terms of the provisions of Rule 7 of the said rules of 1967, imposition of a penalty of withholding increments with cumulative effect not having been provided for, he submits that the same was not permissible to be so imposed upon the petitioner. Mr. Bhattacharjee has further submitted that the disciplinary authority would be permissible for the disciplinary authority to only impose penalty which has been set out in the provisions of the rules governing such disciplinary proceedings, departmental proceedings. So, Mr. Bhattacharjee, by referring to the order of the appellate authority, by highlighting the delay occasioning in issuing the same, has submitted that the appellate authority had not applied its mind to the contentions raised by the petitioner in his appeal memo, and had by fully referring to the order of penalty imposed upon the petitioner by the disciplinary authority without further examining the basis for imposition of such penalty, which was highlighted by the petitioner to be perverse in his appeal memo, the appeal came to be dismissed. He submits that the said appellate order would also mandate an interference from this court. In the above premises, Mr. Chaji praised that this court would be pleased to set aside the impugned orders, or to set aside the orders impugned in the present writ petition and impugned writ petition, and thereby impugned writ petition, full stop. Next, per contra, Mr. Mr. J.K. Goswami, learned counsel, learned additional senior government advocate appearing for the state respondents, submits that the plea taken by the learned counsel for the petitioner that the charge leveled against the petitioner was vague is clearly untenable, inasmuch as a perusal of the charges so framed against the petitioner, it is discernible that the same was so leveled against him with regard to the period when the petitioner was serving as the divisional police officer, Gosaigaon, as well, and during the period when the communal violence had erupted in the area. He submits that these two parameters having been set out in the allegation so leveled against the petitioner, the plea taken by the petitioner, learned counsel for the petitioner, that the allegations leveled against the petitioner was vague, would not mandate an acceptance from this court. Mr. Goswami has submitted that what was alleged against the petitioner was the inaction on his part to take appropriate measures at the time when the communal violence had erupted in the area wherein he was so posted as SDPO, Mr. Bachaji submits that the same is also evident from the allegations leveled against him. Mr. Goswami submits that a perusal of the charge framed against the petitioner, which relates to commission of serious lapse and willful dereliction by him of duty, as well as negligence of duty, would indicate, when read in the context of the charges, it would be revealed that the same is not vague as alleged by the counsel for the petitioner. Mr. Goswami, by referring to the inquiry report, has submitted that the inquiry officer, that the findings recorded by the inquiry officer is found to have been so recorded basing on the materials coming on record in the inquiry. He submits that in the inquiry, the departmental witnesses, the deposition of the departmental witnesses had brought on record the fact that the petitioner, when they said communal violence had erupted, had not, although was posted in the area, had not taken steps for containing such violence, which had led to the spreading of the same to the nearby areas. Mr. Goswami has submitted that the evidences adduced by the departmental witnesses had brought on record the fact that the petitioner was not found to be discharging his duties during the period 27/2012 for 3 days, and accordingly, the same being the period when they said why communal violence had so erupted, the negligence, dereliction of duty as alleged against the petitioner was established in the inquiry. Mr. Goswami has submitted that the inquiry officer, for the purpose of arriving at his conclusions with regard to the materials coming on record, had to apply the principle of preponderance of probability and not the principle of proof beyond reasonable doubt. He submits that the materials coming on record, when examined by applying the principles of preponderance of probability, it is seen that the findings recorded by the inquiry officer in the matter would not mandate an interference. Accordingly, Mr. Goswami submits that the inquiry officers, findings of the inquiry officers having been concurred to by the disciplinary authority, the penalty of a lenient penalty came to be imposed upon the petitioner of withholding of one increment with cumulative effect, which according to him would not mandate an interference from this court. So in the above background, Mr. Goswami has submitted that this court would be pleased to uphold the penalty as imposed upon the petition so as to maintain the discipline of the force and not put a premium upon the dereliction of duty established against a responsible duty or responsible police officer in the inquiry. I've heard the learned counsel for the parties and perused the materials. I'll give my conclusion. Anything left out? Nothing has been left out?
That defense witness happens to be his PSO and driver.
That I'll get it in my PSO driver. And which for which you wanted to establish that I was there because they were moving around. Logbooks are there. They could have produced those logbooks. That's it. Disposal. All probability I will interfere with the penalty. On merits, I'm going to do it.
Yes.
I'll be rising by 3 because I have a division bench. Any matter, urgent matter is there after this item, you can make a mention.
My
Yes.
lord, I think to be best of the adjudication, I think this matter should not be finalized today because I'll just show my lord that paragraph 20 of one of the judgment where what my lord has said about section 14 of the Limitation Act. Then I've come across this paragraph 20 only. So I think bit further study is required, my lord. So I'll pray for some time, my lord. After looking at this para 20, though I relied on this decision earlier,
This is by I could.
yes. And this was
But there are decisions.
yes, so this was the case over here. Writ petition was filed earlier. That was dismissed in limine. Then direction was issued for filing the election petition. And the election petition was filed with the delay petition.
No, is it also a situation wherein there was no election?
No. There was no
Election tribunal available.
at that time. No. This is
That
not
is
the case.
case here.
No,
I've seen this. Suppress of judgment I've seen. And there is a decision of my Lord Justice B.K. Sharma from Arunachal Pradesh.
Yes, your lordship has seen. I've gone through that. That is 2005.
And this is 14.
This 14. My lord, in the first page, in order to see, I think I tried.
22, my Lord Justice Sapre was not here.
No, I think it's 18.
So you said 16, 12, 22. Anyway, we'll have to hear this. Anyway, Mr. Ullam, this is my tentative.
Yes, I'm submitted the gazette notification also, madam.
No, I got it. What do you say on this issue? You are the man in the thick of the things.
May I have the judgment
What I
back?
propose is to send back the matter.
To tribunal.
No, not to send back the writ petition. When people like Mr. Abedin is there, it will be very dangerous for Mr. Ullah. He will finish it off on the first day itself. What I propose is that we close this writ petition, giving liberty to the petitioner in view of the fact that there was no tribunal at that point of time to institute a proceeding. But the tribunal will construe this period from the date the writ petition was filed, because it was filed within limitation.
Yes, madam.
Till the date I give, say 10 days, 15 days, whatever I give, to be excluded under 14. Now, Mr. Abedin has brought a judgment wherein it says, a division bench judgment, it's binding on me, wherein it says that section 14
And
of
5.
the Limitation Act and 5 is not applicable in a proceeding before the naturally correct position of law. But what do you do when you are faced with a situation as we are faced in this?
Yes.
My understanding is also that lordship is thinking I am also with that, my lord. Because
No, I want
Principal
a,
has not-
No,
I want
even
a
I'm
broad
thinking the same way.
consensus. I want a
No,
broad,
even I'm thinking the same way. I said before the thing.
you all agree, I'll close it.
No, but with
Because-
Okay,
this,
you examine.
yes, my lord. Let me examine.
I'll also examine, my lord. Okay.
Third deal on a counsel for the parties at some length. However, hearing remains inconclusive. Registry to list this matter again
Back to ZLD.
on. You're coming back on 5th?
My lord, let it be on 12th.
12. Okay, 12/3/2025. 26 for final, for further further hearing.
May,
I'll also do my research on the
may I have the judgment, my lord, back?
Hey,
My lord, another thing, I think there was an appeal, my lord.
this is an appeal.
No. In that, what my lord, Mr. B.K. Sharma has passed this order in the Arunachal matter. There was a writ appeal.
Then
I tried my level best, but that is not
we'll
online.
try to find. It was a copy.
My number to legal appeal.
I think it is written over there. I think in the.
Anyway, just check up. Mr. Ullah, you also
Yes.
try to find out, because this is a gray area.
Yes.
My lord, that writ appeal is 183 of 2005.
Just give it to her. We'll find it out. That is 183 of 2005 AP.
Not AP. It's just written, I think it is over here. That time AP possibly division was not there. And date of disposal is 15/3/2005.
আমি যেটো দিছিলো তাৰ
It will number to look it also.
I tried my level best but could not get it, my lord.
Now 2005 orders, it's not, I don't think so, it's upload.
I think from this court only the file has to be called.
We'll see.
Abla
Mr. Ullah, if you get something, we are having it on 12th.
We'll go.
Either party gets something,
Yes.
if possible, give it to her a day or two before, so
Yes.
that I can also come prepared.
Yes.
Definitely,
I'll also
ma'am.
try my best.
Definitely, ma'am.
Yes. Abla.
But Mr. Ullah, otherwise, this is the tentative view.
Yes, Lord.
And we'll see to that Mr. Abedin agrees.
No,
to that.
If 14 allows, my lord, I'll agree, my lord.
Abla.
Wait, please, your lordship. Lordship, in criminal case, Lordship Padhat, Lordship are asked, directed to give a short note in that case.
But Mr. A.M. Haloi, Learned Counsel for the petitioner, also heard Mr. P. Naik and Mr. R. Dhor, Learned Standing Counsels, Public Works Department, appearing for the state respondents. The petitioner in the present proceedings has assigned a notice dated 9/3/2016 issued by the executive engineer, Sipsagar State Road Subdivision. Sipsagar State Road Division, intimating the petitioner that he would be completing 60 years of his service as on 30/4/2016 and would retire from his services on the said date. Also, the petitioner as projected in the petition, next paragraph. The petitioner was engaged as a master roll worker in the establishment of the respondent number 3 with effect from 3/1/1984. Also, the petitioner being a pre-1493 appointee, the case of the petitioner was shortlisted for consideration for regularization of his services. Accordingly, the particulars of the petition was forwarded to the government for the for consideration of his case for regularization of his services. Also, in the particulars of the muster roll staff, so forwarded, comma, against the name of the petitioner, comma, his date of initial engagement was recorded as 3/1/84, while his date of retirement was recorded as 30/4/2016. Also, recording of the by construing the date of his retirement as 30/4/2016, comma, his date of birth would work out as 19 1/5/1956. Full stop. The petitioner being found to be eligible for provincialization of his services, comma, the name of the petitioner was included in the final list so approved by the government. Accordingly, the petitioner was wide a communication dated 39/2005 regularized in his services against a personal post created for the purpose with effect from 22/7/2005. Also, in the list so approved by the government, comma, also the date of retirement of the petitioner was recorded as 30/4/2016. Also, after the petitioner was regularized in his services, a service book of the petitioner was opened by the respondent number 3. Also, thereafter, therein, by reckoning a school certificate produced by the petitioner, comma, the date of birth of the petitioner came to be recorded as 31/12/1969. Also, as the petitioner was continuing in his services with the date of birth recorded in his service book as 31/12/1969, comma, the impugned notice came to be issued to the petitioner requiring him to proceed on retirement on reaching the age of superannuation with effect from 30/4/2016. The petitioner by contending that he was entitled to continue in his services till the year 2029, basing on the date of birth as recorded in his service book as 31/12/1969, comma, the petitioner has instituted the present. Mr. Alloy, by reiterating the facts as noticed herein above, has submitted that a date of birth having been recorded in his service book by the respondent authority and the petitioner being permitted to continue in his services in pursuance to the same, comma, the respondent authorities without first carrying out a rectification exercise of the date so recorded in the service book of the petitioner basing on cogent material, comma, could not have altered the date of birth of the petitioner as well as his date of birth of the petitioner recorded in his service book as well as the date of his superannuation. Mr. Alloy submits that the decision on the part of the respondent authorities to require the petition to proceed on retirement on reaching the age of superannuation with effect from 30/4/2016 was an unilateral action without any reference to the petitioner. He submits that the petitioner was not put to notice that his date of birth recorded in his service book had been corrected for reasons so disclosed. Mr. Louis has further submitted that the plea taken by the petition, by the respondents in the present proceeding is to the effect that in the event the petitioner's date of birth is construed to be 31/12/1969, he at the time of his entry into service on muster roll basis with effect from 3/1/1984 would be aged around 14 years and the petitioner at the relevant point of time should be considered to be a minor, and it would not be permissible for him to enter into the services of the government. Submits that the period of service, that it was not an uncommon thing at the relevant point of time or to engage underage persons in government services against grade 4 posts, and accordingly a concept called apostrophe boy service apostrophe over was so evolved for the purpose. Mr. Holloway submits that the petitioner's boy service with effect from the date he had entered into services till he attained the age of 18 years would be required to be excluded from the period of qualifying service rendered by him for the purpose of determination of his pension and pensionary benefit. However, he submits that on the said plea, the date of birth of the petitioner as recorded in his service book as 31/12/1969 would not mandate a correction. In the above premises, Mr. Holloway submits that the notice dated so and so be interfered with, and the petitioner already continuing in his services in terms of the interim directions passed by this court in the present proceedings, he be permitted to continue in his services till the date of his superannuation by reckoning his date of birth as 31/12/1969. Also, per contra, Mr.
Lord, can I point out one thing?
Yes.
Lordship permits. Your Lordship goes to the page 16, the serial number 1 person, he was engaged on 1/1/1982, the first one. And date of retirement is recorded as 31/12/2025. In that case, my lord, the age of that person, if my age would be counted at 18, which I'm just pointing it to your Lordship. Because 1/1/82, then it would be 19 years up to 2000, then 25, 44. Had it been 18, 44 plus 18, it would be 62. He was engaged prior to me.
He would be aged around 17 years at that point. Anyway. Also, per contra, Mr. P.D. Naik, Learning Counsel for the petitioner, and Mr. R. P.D. Naik and Additional Advocate General, along with Mr. R. Learned Standing Counsel, Public Works Department, submits that when the name of the petitioner was compiled, when the list of persons eligible for regularization, a list of muster roll workers working in the establishment of the respondent number 3 was when the list of muster roll workers working in the establishment of the respondent number 3, found eligible for having their services regularized was so compiled, therein the date of superannuation of the petitioner was recorded as 30/4/2016. Also, it is submitted that basing on the said date of birth as recorded in respect of the petitioner in the list of muster roll workers found eligible for regularization of their services is reckoned, the date of birth of the petitioner would work out to be 1/1/1956. Also, it is submitted that basing on the said disclosure made in the list so prepared, the competent authority on examination of the same, along with the contemporaneous records, had proceeded to grant approval to such a list so prepared of the master roll workers in the establishment of the respondent number 3. So, it is submitted that upon the approval so granted, the name of the petitioner was so incorporated in the list of muster roll workers found eligible for regularization of their services, and the same was circulated by communication dated 30/9/2005. By the communication dated 30/9/2005, the names of the persons included in the list and enclosed thereto came to be regularized with effect from 22/7/2005. It is submitted that in the said list, the name of the petitioner figured with his date of superannuation as 30/4/2016. The petitioner was, it is contended that the petitioner was in the know-how of the particulars recorded against his name in the said list appended, annexed to the, enclosed to the communication dated 30/9/2005. However, the petitioner did not take any steps for a rectification of such particulars in the event the same was not in accordance with the records maintained in the establishment of the respondent number 3 with regard to the service particulars as well as the age of the petitioner. It is submitted that while the service book was open, the then incumbent in the post of executive engineer, PWD, Sipsagar State Road Division, by relying upon a certificate, school living certificate produced by the petitioner, proceeded to record the date of birth of the petitioner in his service book as 31/12/1989. It is submitted that the said date of birth as recorded in respect of the petitioner is clearly contrary to the date of birth as working out from the particulars recorded against the name of the petitioner in the list of eligible muster roll workers found in the list of muster roll workers found eligible for a regularization of their service. It is submitted that the petitioner, not having questioned the particulars as recorded in his service in the list of eligible muster roll workers, it was not open to the respondent number 3 to record a contrary date for the purpose without first coming to a conclusion that the date of birth as disclosed by in the said list of muster roll workers in respect of the petitioner was erroneous. Also, it is further submitted by the learned counsel for the respondents that in the event the petitioner's date of birth is reckoned as 31/12/1969, he would be underaged as on the date he was initially engaged on muster roll workers in the establishment of the respond number 4, and the same would be in violation of the governmental norms laid down in the matter of recruitment of persons, underage persons. It is submitted that a minor was not, it was not permissible for the respondents to engage a minor for the works or any works in the establishment, including the works required to be discharged by a muster roll worker. Accordingly, it is submitted that the date of birth recorded in the petitioner's service book as 31/12/1969 was so recorded on a erroneous projection made by the petitioner, on a misrepresentation made by the petitioner by relying upon a school certificate. It is further pointed out that the school certificate relied upon by the petitioner was not verified by the district administration as per the procedure mandated in this connection. Accordingly, it is submitted that for the purpose of arriving at the conclusion with regard to the date of birth of the petitioner, the said school certificate relied upon by him, produced by him at the time of preparation of his service book, would not mandate an acceptance. Also, I've heard the learned counsel for the parties and perused the materials available on record. The facts noticed herein above are not in dispute. Also, however, the rival contentions advanced by the petitioners, brings to the forefront a dispute with regard to the actual date of birth of the petitioner. While in the documents prepared for the purpose of regularization of the services of the muster roll workers working in the establishment of the respondent number 3 prior to 1/4/1993, it is seen that the date of birth of the petitioner, basing on the materials available on record, was recorded as was denoted as 34/2016. The said date of birth as recorded against the name, the date of retirement as recorded against the name of the petitioner, if reckoned, the date of birth of the petitioner would work out as 01/01/1956. Also, it is seen that on the particulars of the petitioner and other muster roll workers covered by the policy of the government in that for regularization of their services being approved by the government, a list was so prepared of such eligible muster roll workers, and the same was circulated by as an enclosure to a communication dated 30/9/2005, through which the services of the persons whose names were incorporated in the list enclosed thereto came to be regularized. The name of the petitioner herein also finding mention in the list so enclosed, his services was also regularized with effect from 22/7/2005. It is seen that the petitioner, after the issuance of the notification of the communication dated 30/9/2005, along with the said list enclosed thereto, had not taken any steps for correction of his date of retirement as denoted in the list so enclosed to the denoted against his name in the list so enclosed to the communication dated 39/2005. Also, however, a parallel process is seen to have been initiated in the matter by the then incumbent in the post of executive engineer, Sibsagar State Road Division, while preparing the service book of the petitioner. Also, in the service book so prepared, the date of birth of the petitioner was recorded as 31/12/1969. And the same is found to have been so recorded basing on a school leaving certificate produced by the petitioner from government aided Hafaluting High School, Hafaluting High School, Sibsagar. Also, although the said document would be a valid document for the purpose of determining the date of birth of an employee concerned who has not studied up, who had not cleared the HSLC examination, it is the requirement that such certificates have to be verified and countersigned by the jurisdictional deputy commissioners, presently district commissioner. The said certificate is not found to have been authenticated, countersigned by the deputy commissioner, and accordingly, the validity thereof remains shrouded in mystery. This, when viewed with the date of birth emanating from the particulars recorded against the name of the petitioner in the list of muster roll workers found eligible for provincialization of their services, a disputed question of fact comes into the forefront. Adding to the said mystery is the fact that in the event the date of birth of the petitioner is taken as 31/12/1969, his date of engagement as muster roll worker being on 3/1/1984, the date of engagement not being in dispute, the petitioner is found to be a minor, aged about 14 years on the date of his such engagement. Also, it is not normally permissible for any authority, any person of the authority to engage a minor to employ a minor, and the same law was applicable even as of 1984. The petitioner was so engaged. However, if the date of birth of the petitioner is reckoned as 1/1/1956, he is found to be a major on the date he was so engaged as a muster roll worker in the establishment of the respondent number 6, respondent number 3. So, accordingly, this court is of the considered view that the date of birth of the petitioner as recorded against his name in the list of eligible muster roll workers found eligible muster roll workers whose services were approved for regularization by the government. No, I have sentence to go. List of muster roll workers approved for regularization of their services, adds authenticity to his actual date of birth, while the date of birth as recorded in his service book, basing on a school leaving certificate which was not authenticated by the jurisdictional deputy commissioner, bracketed, now district commissioner, would not mandate an acceptance. Also, in view of the above position, this court is of the considered view that the date of birth of the petition as projected by the respondents, that is 1/1/1956, is required to be so accepted. Also, accordingly, the date of birth, the date of retirement of the petitioner would fall on 30/4/2016, and this court does not find any error committed by the respondent authorities in issuing the impugned notice dated 9/3/2016, requiring the petitioner to retire with effect from 30/4/2016. Also, having drawn this at conclusion, this court finds that this court finds that this court notices that in the present proceeding, while order dated
27/4/2016.
Huh?
27/4/2016.
27/4/2016, while issuing notices, this court had stayed the effect and operation of the impugned notice dated 9/3/2016 and permitted the petitioner to continue as a grade 4 employee in the establishment of the respond number 3. It is submitted at the bar that the petitioner thereafter continued in the said capacity. And a petitioner is continuing in the said capacity till date. Also, this court, having not accepted the date of birth as recorded in the service book of the petitioner, and having concluded that the date of birth of the petitioner to be 1/1/1956, further continuance of the petitioner in his service in terms of the interim direction passed by this court would not be sustainable. Accordingly, the petitioner is held to be not eligible to continue any further in his services. Also, with effect from 27 to 2026. Also, in view of the above conclusions, the petitioner is held to be entitled to receive all benefits as a pensioner with effect from 1
With 1/4/2016.
1/4/2016. Also, the petitioner having drawn his salaries with effect from
30/4/2016.
with effect from pension from 1/4.
Pension from 1/5.
34/2016.
Pension from 1/5.
1/5/2016. Entitled to pension from 1/5/2016. The petitioner, having drawn his salaries with effect from 1/5/2016, and this court, having held the petitioner to be not eligible to continue in his services after 27/2/2026, for the period with effect from 1/5/2006 to 27/2/2016 1/5/2016 to 27/2/2026, the salaries drawn by the petitioner would not mandate to be recovered. However, for the said period, the petitioner would also not be entitled to be authorized any pension. Also, the petitioner would now be entitled to draw his pension with effect from 1/3/2026. Also, the respondent authorities would now prepare a pension proposal in respect of a proposal for release authorizing to the petition pension and pensionary benefits with effect from 1/5/2016 in the manner indicated herein above, the arrears being receivable from the actual benefit being receivable from 1/5/2006, 1/3/2026, and submit the same to the Office of the Accountant General, bracketed A&E Assam, for disbursal till the finalization of the petitioner's pension and pensionary benefits, comma, the respondent authorities, the PW authorities would authorize to the petitioner a provisional pension with effect from 1/5/1/3/2026, and the same shall be continued till the final pension and pensionary benefits are released to the petitioner. With the above observations and directions, the petition stands disposed of. You take rest. You have served enough. Some young man will come in now. Yes. Any interim order to be extended? 12. Interim order is there.
Interim order is there. The cover case, my lord.
12 there.
Item 60, my lord.
Huh?
Item 60, my lord.
60. I'm sorry, today there were some matters which actually took 12 likha, 60 likha. Haru?
I pray for.
You do one thing. Just put in a note the numbers wherein you want the interim orders to be extended. Give it to her. She will do the needful. I'll pause.
I pray for fixing a date, my lord, in respect.
Give it to her. She will fix it. Yes. Some petitioner in person. Yes, Mr.
Item number 85, my lord.
80?
85.
81.
85. 85.
That aeronautical college, man.
Yes, my lord. Yes. So that may
Some chanda, that or some engineer, something. What is that? What do you call that? Authoritative.
that is DGCA, my lord.
No. That post
Post accountable manager.
accountable.
Lord, sir.
When? When do you want it?
10th, if it is possible, 10th or 11th.
11th, yes.
What's it? Deeply.
On the prayer of the learned council for the parties, on the prayer of the petitioner in person and the learned council appearing for the respondents. Registered to list this matter again on 11/3/2026.
Deeply obliged.
Praying for a date, man.
She'll give it to you.
Yes.
Don't worry. Silent was interim order as a belegata list bonite level. And if there is some very urgent matter, you can just tell her I can come back, and if required, I can sit here. There is no problem. The only thing, how long it will take, I don't know. It might just
Only the
all-
series, only the series may be fixed at a.
series. What happened? Who is the for the respondents in the series?
Your lordship was pleased.
Yes. Who is there? Respondent. Yes, Mister. Come.
The reason.
Yes.
Mr. Khatoner will be.
Whoever is. What is the reason? Where is your letter?
I will just.
I'll come back if required.
Just confirm once.
Tinta punarpasa na. Yes, Miss. Madam, why are you having such a gloomy look in the evening?
87 contempt, lordship has fixed this case today.
Who is appearing in item number 87?
Mr. Patunia he's coming, your lordship is on his way. He's coming.
And in 87 also, Mr. Khatonia has filed the affidavit.
I'm not aware of it.
87
87 to
contempt. Relates to drop it.
Okay, we'll do like this. We'll come back.
Yes,
We'll
yes.
come back. I'll finish it and come back. I'll come back. Baki GS did the details. Urgent as a series and that I'm coming back.
And my case also.
Yes.
The copies of the writ petition, my lord. Because of our mistake, my lord.
This is serious.
My lord. My lord may take it up after a week, my lord. In the meantime, I will file affidavit, my lord.
No, I don't have anything. I don't want to take it up also.
Fine.
You do it whenever you want. But thing is, why was this aspect not pointed out? So what about the other cases? This is only one case.
My lord. Other cases also, my lord, they have not received the copies, my lord. But it is not written here, my lord. I have talked with them, my lord.
Copies you have written.
My lord.
Copies were with you. Why this? And the matters are unnecessarily pending here.
My
Miss S. Chutia. Oh, Unnari. When are you filing the affidavit?
My lord, after a week, my lord.
You give me a date. In all the cases.
My lord.
When?
इसकी सभी से ना 9th or 10th, my lord.
We give you time till 13.
My lord.
File your affidavit, then we will take up the.
My lord.
We'll have the matter on 17.
My lord.
It would be around 19.
20.
My lord, one thing, it can be also from,
Whenever you are comfortable.
let it be on 16th. We'll have a try. Possibly might have to go for another date also.
Okay. You file it by 11th.
My lord.
Ms. S. Chutia, in response to the directions passed by this court-wide order dated 22/2026, has placed on record the written instructions received from the Director in charge, Elementary Education Department. So it is the contention of the respondent that the copies of the writ petition were not furnished to the department, and accordingly, the instructions thereagainst could not be provided to the learned standing councils. Ms. Chutia has taken it upon herself that the non-forwarding, that the copies of the writ petition also, although furnished by the petition learned council for the petitioners, was inadvertently not forwarded to the department, and she ensures that such lapses would not occasion in future. Also, the explanation provided are accepted. Ms. Chutia has further submitted that she would file the affidavit on behalf of the respondents in the above noted writ petitions on or before 11/3/2026. Accordingly, registered to list this matter again on 16/3/2026. As the date for filing of the affidavit has been so fixed, basing on the undertaking given by the learned council for the respondent, learned standing council, Elementary Education Department, this court, in the event the affidavit is not filed on or before 11/3/2026, would pass appropriate orders as would be called for in the matter for the default that would occasion on non-filing of the affidavit.
The interim protection passed.
Interim orders passed, if any, in the above noted writ petition shall stand extended till the next date of listing.
Applied. Deeply applied.
87 today. Who has filed this affidavit?
Dantas.
I have filed.
He filed.
No.
Oh, yes.
Who is the authority who has filed?
The director.
Director.
Trustee has the authority on 23/2/2006 to be filing this affidavit.
23/2/2026.
26. That is the date when the affidavit was shown before the notary.
Hello.
And come to page 56. 1.
Hello.
I am holding the charge. This officer is not holding the charge. This officer is the director. But I find that the director is not there, some person and in charge basis is holding the post. How can, when an in charge arrangement is made, the earlier incumbent come and file an affidavit?
I'll have to take clarification.
I think you will have to withdraw this, file it appropriately.
I'll withdraw this.
And my lord, speaking order also against the order passed by this honorable.
That will come later.
Yes, my lord.
Mr. I'm allowing you to. Mr. B. I'm not going into we all know what has happened. We don't want to go into that. Mr. B. Kaushik, learned counsel for the petitioner, prays that the affidavit filed be permitted to be withdrawn on account of certain errors existing therein. He submits that an affidavit would be filed on behalf of the respondents. Respondent number 5 on the, this is a
Contempt.
contempt. Oh, then it's okay. Then it's okay. But why this charge thing? Okay, yes. It's a contempt, then it's okay. We will not proceed any further. Contempt. Technology.
Hmm.
But statements are not correct. Okay, fine. Yes, madam, what is the error?
Lordships, kindly peruse the court's order.
Hmm.
It was stated that the 2 years criteria has already been condoned. Your lordship knows that that day also your lordship has passed an order. But in order, my lord, they have stated like this, lordships. Not a type you need your head. The last page, 6 to 1. And there is no review against that, my lord. But it is mentioned then there is a review also. Review was not filed, my lord.
And where are only the 2013 Act is set aside, the earlier acts are not being set aside.
They're not set aside. They have stated that all the acts have been set aside. Struck down.
Mr.
My lord. See, my lord, after when the 2012-11 Act came in, my lord, that all the earlier Prohibition Act.
Check.
Take.
I mean,
I have already gone through it.
found somewhere, my lord, in
নাই কৰা।
এখন আহোঁতে
অকল 11খনহে কৰিছে।
নহয় 11 আহোঁতে
বাকীবোৰৰ কথা কোৱা নাই।
Yes.
ভালো
Not been set aside. This was a
Yes.
new act brought into being. Because earlier Act 77 Act has not been set aside.
That order has already been regional. The court's order, my lord. And the review also petition was not filed, my lord. So far my knowledge goes. No review was issued, filed at that time. 1571/1998.
Mr. Kaushik, that
My
acts
lord.
have not been set aside. So this is a wrong.
No, no.
Hmm?
No.
মই দেখিছো
On the present
I'll
question,
examine it.
learn a
Look, I-
counsel for the petitioner.
I think I've seen somewhere, my lord.
Huh?
I've seen somewhere, my lord, after
Okay.
when this
Very
2011
straight to list this matter again on 18/3/2026. You also just go through this.
Yes.
And we think that you have made a mistake there.
my lord,
The order, I don't think so. It's in connoissance with the directions.
direction. I'll that
Once
examine
the
that.
court has said you act, you will have to act until and unless you don't. So if there is something to be done, do it.
I'll examine, my lord.
Do it.
Before 18, my lord, I'll,
Do it and pass fresh orders. What is there?
my lord.
Right. So far my knowledge goes, it is not struck down. Yeah.
So,
Yes, my lord.
not struck down, my lord. I think it was repealed by
Not repealed.
1977 Act still.
77.
Still exists.
That is the earlier one.
In my case.
77, then 2011.
82.
2011.
Then amended in 2012, 2007.
Seven.
Much only. 77 to 2011, there is nothing. And 2011 has not repealed at 77. They cannot because that is otherwise also a
It's a fresh
fresh.
legislation.
And your 82 rules will go.
Yes.
Yes.
7 under the
2013
77
will go.
Act 81 rules.
Just check up.
I'll
Bless.
grateful, my lord.